All mentioning list be given to my court officer. I will only take the mentioning with regard to the any urgent unlisted motion.
Your Lordship,
Whatever the mentioning, give the mentioning list to my court officer.
I like to withdraw this case, my lord, and because tribunal has heard the matter, and so I don't like to reply to that.
Your Lordship.
Your Lordship.
In the list, on command list, 549 item, my lord.
Okay.
Your lord, pass the order.
Your Lordship.
Lordship, this matter.
Okay, I will see. If you've given the urgency, I will see, and atonement can tomorrow or day after tomorrow contact my court officer. You will get the date.
Your
Lordship,
Lordship, this. Lordship,
concluding the hearing by both the parties with the consent. This can be fixed on 29th.
Who is for the other side? To be mentioned, mein kar do.
Lordship, this matter.
Fixed day after tomorrow has to be mentioned. Inform the other side in presence of both sides. Then I will fix the matter.
On Thursday,
Day after Wednesday, it will fix at to be mentioned.
Yes.
Call the other party. Then I will fix the date in presence of the other party. Your
Your
Lordship.
Lordship, this matter has to be heard tomorrow, Your Lordship. Your Lordship, I am a chartered accountant against whom disciplinary proceedings have been initiated by the ICAI on the basis of an anonymous information, Your Lordship. Despite there being a statutory bar against entertaining any such anonymous information, Your Lordship, they have proceeded to keep the matter for hearing on merits on 17th of June, Your Lordship. Your Lordship, the matter has to be heard tomorrow, Your Lordship, since the writ petition challenges the
When you
maintenance.
file the writ petition, already I think I already given the date.
Your Lordship, we haven't
On
received.
the last occasion, you moved this.
Your Lordship, I had given the slip, but
Yes.
on consulting with the officers, Your Lordship, we didn't get a date specific.
Why? Date is not given.
আমি slip দিয়েছিলাম। Slip
I have given the. If people not given the urgency, then I might have been crossed it. If
No,
you
Your
have
Lordship.
given the urgency, I might have been given the date.
Your Lordship, the matter has to be heard before 17th, Your Lordship. The matter has to be heard before 17th. Since on 17th, the matter will be heard before the,
Here.
Your Lordship, the disciplinary committee of the ICI will hear the matter on merits.
What the
Your
court
Lordship.
will do with regard to the disciplinary proceeding?
Your Lordship, the writ petition challenges the maintainability of the entire proceedings which has been initiated by the ICAI, Your Lordship.
I am permitted to mention, Your Lordship.
कल के बीच within 5 minutes.
Your Lordship, may I permit you?
Much obliged, Your
And
Lordship.
Your Lordship, urgency is that there is an appointment notification given by Chapter Bhavan for the tender regarding the housekeeping and cleaning. Your Lordship, what's the problem is that, Your Lordship, there is a specification on the condition that the government contractor who are applied, they should be in their prior experience regarding to hospital. My client is, Your Lordship, they are government contractors in the other section. The challenge is the NIT, Your Lordship.
So how you can challenge the terms and condition of the contract? It is the authority to put the condition. How you can challenge that? If you are not having the experience, and how you
Have the experience, Your Lordship. What's problem is that there is specification on the regarding that marks the government contractor. The 3 years experience regarding the government hospital. The earlier NIT.
What is the last date of the
Tender last, there are many changes.
when the tender was published?
It was published in 19 May.
19 May. What is the last date?
The last date regarding many government hospitals are given the last date 20 June for the bid closing of the tender. I am couldn't apply for the tender bid also.
So 19 May. Why you are not filed the earlier? Why you are waited for the last day?
The complaint on the portal side, there is no complaint box also in the portal side.
That's why I'm asking, when is the last date of the tender?
20 June. Cases came. Different hospitals give it different date, but 20
With regard to your tender, which is the last date?
20 June.
What can be done?
Any day you Lordship, so next week you Lordship, Monday.
You are telling the 20th June, then you are telling the next week?
20th June, Your Lordship, in subject to correction, Your Lordship, any day in this week, Your Lordship.
No, what is the last date? See the tender. What is the last date? You are not.
June, Your Lordship, 20 June, Your Lordship. 20 June 2026.
What is the time?
3:30, Your Lordship.
19 then within 10 minutes. Leave is granted. File the same and issue notice to the all parties. 19 June within 10 matters as under.
Your Lordship, may I permit to mention the list?
No mentioning list. Yes,
My lord,
you
may-
mentioning
my
list.
lord, may I be question a matter?
Only I will take the unlisted motion. Yes.
Your Lordship,
My
may I
lord,
permit to mention the list?
Matter, it is very urgent, my lord.
Give the urgent slip, my court officer.
My lord, I've served the other, I've,
I'm a pharmacy student who have been outside of the document verification process by the West Bengal Pharmacy Council on the ground that my SIR appeal is still pending. Your Lordship, we don't know when due to be heard. Your Lordship, there is a delay in the hearing in the process. Your Lordship, kindly give it some preference because my academic career will get lost.
You have given the mentioning list. Give the mentioning list.
my lord, I've
May I
served,
permit to mention the list, my lord?
my lord, kindly,
I will not allow any mentioning only unlisted motion I will take. All mentioning give this list.
my lord, I've served to the opposite party, my lord.
Lordship, your Lordship.
Give the list.
My lord, my lord, despite proper documents, I've been arbitrarily cancelled in Punjab
May I
National
permit
Bank.
to mention a leaf, my lord? The petitioner is, name has been deleted from the electoral roll. And my lord, meanwhile time, the petitioner has been selected for the PhD program in IIT Kanpur, my lord. And whose admission date is on 27th July. And due to the deletion, my lord, he is facing several administrative problems.
What administrative problem?
My lord, 27 is the
27 July.
Huh.
What is the urgency?
July is his admission date, and my lord is basically he is facing difficulties on his registration process, my lord, due to the deletion, my lord.
What registration process? Once you selected, it is a fixed on 27. What is the process? What further problem you are facing?
His name, as his name has been deleted, my lord. So authorities are assuming that he is not a citizen of India, and due to which he is facing several issues.
Citizen of India will decide the SIR. Citizen of India will
No,
decide
my
the
lord,
SIR.
there is a apex court order passed, but
So that's why I'm telling. Why
After
this court?
my lord, if
What is your prayer, sir?
my lord, my prayer is if the matter has been adjudicated as soon as possible, my lord,
Who?
by the tribunal. If we were
When you prepared an appeal?
6th April, my lord.
24th June.
My lord, kindly consider the urgency of the matter. My lord, I'm a disabled person.
Give the mentioning
My lord,
list.
despite clearing the
The list.
my lord,
Give the list.
My lord, this is withdrawal.
Whatever it is, give the list to my court officer.
Given it.
My lord, item 362, my learned junior is handing over the slip, my lord. This is item 361. The urgency, my lord, is that, my lord, we have been dispossessed, and my lord, unless, my lord, it is taken up.
Mr. Whatever this give the mentioning list, I will consider
lord.
it.
My lord, I'm deeply obliged. Deeply obliged.
Last Monday, I have.
my lord, I'm suffering from illegal detention.
Yes, call the list. Call the list. Call the list.
Two came
My lord,
matter, my lord. One has been taken up, my lord. Another is still pending, my lord.
The matter was
Alright. Nothing. Whatever the urgency, you give the mentioning list. Yes.
Your lordship, the petitioner was a land user in the process of acquisition of land by the Your lordship, this matter had been mentioned, your lordship.
Why did you mention?
11th of May, it was fixed, your lordship. Now, your lordship is not sitting on that day, your lordship.
Who is for the other side? Instead is appearing.
Mr. Joyanta Kumar is the other side, your lordship. In the meantime, if your lordship is pleased to fix a date, your lordship, in the
The
meantime.
side is not there. If I fix that, the other side will say that.
My lord, I am informed, I am being the advocate on record. I have sent him the photocopy of the list and also informed him that the matter is appearing in the list as item number 1 and kindly treat my SMS as a official notice. Still, they have not appeared, my lord. And the last order, your lordship was ordered them to obtain the certified copy of the opposition and reply, which I have obtained, but I will serve them the copy, my lord. on last occasion at the time of mentioning, after receiving the notice, they have not mentioned. That's why your lordship was fixed this matter as to be mentioned to fix the date of hearing, my lord. Kindly fix the date of hearing, we will again give him notice.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submit that the notice has been sent to the respondent by informing the respondent that the matter is listed as item number 1 for fixing the date. But in spite of service of notice, none appears on behalf of the respondent. Counsel for the petitioner submitted by an order dated 11th of March 2026. This court has fixed the matter on 11th May at 2 p.m. as a specially fixed matter, but due to non-ability of this court on the date fixed, the matter could not be taken up for hearing. Accordingly, she prays for fixing a date. She prays for fixing a specific date and time so that the matter can be taken up for hearing. At the learned counsel for the petitioner, let the matter appear on 7th August at 2 p.m. as a specially fixed matter.
Kindly grants an earlier date, Your Lordship.
I am for the respondent. Directed to inform the next date of hearing.
Advocate.
10 minutes, the matter has been called. Nobody, now dictation is completed. Now you are telling you are appearing. You are appearing for whom?
For the
Appearing for whom?
respondent.
Appearance for the respondent, my lord.
Respondent, there are so many respondents. DYC, DVC, you are appearing.
Union of India, sir, my lord.
That's why you said you are appearing.
Yes? No, my lord.
Then you see your brief to whom you are appearing.
Union of India.
So, Union of India, what is the role of the Union of India? I want the state and the DVC here.
State Bank, State of West Bengal, not.
That how the Union of India is there.
My lord,
Yes.
All respect to Lordship, the union party.
Call the next matter.
May I humbly pray, my lord, kindly.
No, date is available.
So Your Lordship has been fixed a time.
Yes, 2 p.m.
I'm so grateful. Deeply obliged.
for the petitioner, my lord.
Yes.
Interim order, my lord, expired on 10th. My lord, time to time, my lord, it has been extended.
Hmm.
My lord, finally on the last occasion, my lord, pursuant to last day, they have used their opposition.
Hmm.
My lord, we are filing our reply.
Hmm.
My lord, kindly extends the interim order.
By
And
the
fix it.
10th June, now we are on 18th June.
Yes.
Then,
No, they have used their opposition. We have.
no, 10th June, you are not, thereafter.
My lord,
the
we
order is
opened
not
on
been
8th.
extended.
We opened on 8th. We
Yeah.
mentioned, my lord, on 10th, my lord, it is listed today, my lord, for extension.
Interim order,
11th. We
sorry.
mentioned on 11th.
Yes, 11 you might have been mentioned, so
Mentioned.
what the court will do?
One day, my lord, here and there, my lord.
For the other side.
My lord, we have put them on notice also, my lord. This is our mail, my lord.
None of the petition and the matter is listed as to be mentioned on the prayer made by the counsel for the petition for extension of interim order. None appears on behalf of the
My lord, I am appearing on the behalf of state, but we have not received any copy
what copy?
from other side.
Huh?
From other side.
What copy? What copy you want,
The
madam?
state is not party here, most probably, my lord. Union
What
of
copy
India
you
is the
want?
party.
Mentioned the State of India, item number 2 to.
2. The petition to the.
Be written.
एक मिनट देखें नीचे.
Fine, तो आ गए, sir.
Sure, sir.
The railway, you are appearing for the railway? Is the railway authority? None appears on behalf of the authority, the respondents, which for the interest of justice, the interim order extended till 22nd July 2026 or until further order, whichever is there. Let the matter under the heading urgent motion on 22nd July.
Lord, my lord, I am for railway, man. Railway.
Which matter?
This
matter?
This matter, my lord.
Yes.
It is a misunderstanding.
You are appearing for the
The railway, my lord.
railway. So what is the submission?
So it's today is for extension, it can be done.
I am extended the time and 22nd July.
my lord, maybe file our reply to their opposition.
Opposition is not on record.
Not on record, but they have served on us.
Where is the opposition?
Opposition, we kept with my senior.
When you file the opposition.
I had already served, my lord.
Yes.
20th July, though.
22nd July.
22nd, my much up.
Next.
Lord, I am for the petitioner.
Yes,
Finally, the interim order is going to expire today.
yes.
This was to expire during your lordship's absence. So this was taken up by the Honorable Justice Gaurang Nath, the order dated 18th May 2026.
Yes.
So, your lordship,
Yes. Who is appearing?
I'm for the state, my lord.
Ready?
My lord, directing this.
may I make one humble request? I find from the records at least a dozen times interim order has been extended. So let it be until further orders.
Now, whether affidavits completed?
Affidavits completed by
Hearing.
the earliest stage.
Only hearing.
Yeah, only hearing, and your losses called upon an affidavit from the private respondent to clear their stand.
Who is appearing with the private
Well,
respondent?
I have given notice to him.
I don't need private respondent might have been changed the advocate. The state might be. Report from the 3 to 314. Exception is filed. A report of 314. How many private respondents?
Well, only one. Only one or two. Only one.
The matter is listed as to be mentioned for extension of interim order. Consensus appearing for the state.
Hey, Didi, naam
It is found that the
Copy
state
to
has
the
already
author.
filed the report and the petitioner has taken exception to the said report. Then appears on behalf of the private respondent. Let the matter appear. The date then.
The date code, note down code, item 3.
10th August at 2 p.m. as a specially fixed matter. Interim order is extended till 13th August 2026 or until further order.
Much less. But I have to give a copy to the now new.
Sarthak, go to the Sarthak.
Lordship, may I mention one matter, Lordship? This
This is not the time for mentioning his over. Yes, Mr. Call the list. Call the list.
Now, my lord, this is the case. When I found that, after going to the, I found probably it requires some changes, not complete, with my limited knowledge, of course, my lord. So I just instructed my client better withdraw with a leave to file a fresh one. So now we are going to withdraw these petitions.
Want to withdraw?
Yes, I'm giving leave to file a fresh one.
Learned counsel for the petitioner prays for withdrawal of the present date application with the liberty to file a fresh. Consider the submission made by the counsel for the petitioner. WPA 29782 of 2025 is dismissed as withdrawn. Liberty to file a fresh.
After all, at least I've got a chance to show my face here, only for withdrawal.
Anyhow, but you.
May I leave, my lord?
Thank you. Thank you. Yes.
My lord, I am for the petition, my lord. My lord.
And prosecution.
Yes.
Withdrawal.
Yes, my lord.
Why?
Withdraw. It has this is debit freeze, my lord. It has been resolved. It has been resolved. The bank has resolved the issue.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted, she has received a written instruction from the petitioner that the matter has already been resolved and the petitioner is not intending to proceed with the matter instead for withdrawal of the letter. Consider the submission made by the counsel for the petitioner. Peruse the written instruction. WPA number 9864 of 2026 is dismissed as withdrawn. Full stop. The communication be kept with the record. Next.
Madam, this writ has been filed due to inadvertent mistake, my lord. Filed this honorable court. This is challenging police inaction in pursuance to the order of the section 14. My lord, inadvertently filed before this honorable court, my lord. I'm praying for release and liberty to liberty.
Learned counsel for the petitioner submit that the
mention the
petitioner has inadvertently filed the instant date application before this court. Accordingly, she prays for withdrawal. She prays for release of the present date application from this court with the liberty to mention before the appropriate bench. Consider the submission made by the counsel for the petitioner. WPA number 10866 of 2026 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination. Next.
Grateful.
I'm late by Mr. Participating Royal.
Yes.
Your Lordship, the tender work was Lordship
terminated. The tender was lordship terminated lordship without handing over the site. Now lordship, according to them lordship, the slope due to
Which was
slope.
the respondent?
Metro Railway lordship.
Which authority?
Now
Metro Railway.
Metro Railway lordship.
Which was there? Nobody is here.
Yes, last occasion on Friday there was someone appeared lordship. The Friday lordship, your lordship takes up the matter. Someone appeared.
Fridays were taken. It was heard.
It was hard lordship.
My lord,
I am further.
What is the prayer?
Prayer lordship, the termination for setting aside the termination lordship issued by the lordship railway.
Last question, my lord, I am taking over.
Yes.
My lord is to opine that whether there is arbitration clause or not, whether they will satisfy your lordship regarding the arbitration clause, and whether the allegation which you have made, there is a subjective satisfaction of the work, performance of work, whether the read court can go into those aspects in a tender matter. These are the two things. For that, my lord has take instruction. Only one thing I am drawing lordship attention. So the last annexure, the reply regarding my, if your lordship may kind enough to turn to page
64.
80, page number 270, 271.
Yes.
Because there are two works were been allotted to us, my lord, for which we are there is some delay. We have also these are detailed representation we have made. What are the accounts? On which are the grounds that don't hand over the sites and other things. This is a subject satisfaction. I cannot invite your lordship to adjudicate whether these statements are correct or not. May I pray before your lordship only one thing, whether they can, our grievance may be considered by them, and so if it appears to them, this is a thing I can submit before your lordship. Apart from that, I will not argue anything more. Because on the earlier occasion, my lord is of the opinion, these are the subjective satisfaction of the authority.
Where is the your
arbitration
clause?
Yes.
What is the conciliation clause before that?
Lordship, kindly have a look to my lord. Page 95, clause 63.
It is more than 50 crore.
No, it is not more than 50 crore.
Less than 50 crore.
Less than 50. Subclause 6.
No, the two all disputes or differences if any kind whatsoever arising out of connection, whether during the progress of the work or after the completion, before or after determination of contract, shall be referred to the by the contractor. So let that be decided by the chief engineer in terms of this clause.
Lordship kindly considers, so far as my learned friend's submission is concerned, that we have not taken any decision. We have already taken a decision.
I am not giving any. Only I carry that I record your submission. There is a arbitration clause, and I find that he has already made a representation in terms of 63(2). The chief in this matter may be referred to the chief engineer, and chief engineer may take appropriate decision in accordance.
Grateful, Lordship.
That will be better.
Great.
That is why, my lord, precisely I am not.
Lordship kindly clarifies your Lordship has not entered into the merits of the case.
I am not inviting this court.
I am not telling that.
I am not inviting this court.
The petitioner, though the petitioner has filed the present date application challenging the termination of the contract. The very outset, the learned advocate appearing for the respondent authorities raised the preliminary objection with regard to the maintainability and submit that as per the standard general conditions of contract, there is an arbitration clause if the petition is having disputes with regard to the termination, the petition would have to approach the appropriate authority for arbitration, but instead of taking the benefit of clause 63, the petition has filed the present date application. Learned counsel for the petition submitted after the termination of the contract, the petitioner has made a representation to the senior divisional engineer on 18th of April 2026, but the same has not yet been considered. The senior divisional engineer ought to have referred the matter to the chief engineer for consideration, but the same has not been done. Consider the submission made by the counsel for the respective parties without going into the merit of the matter. This court disposed of the present date application by directing the senior division engineer South Metro Railway Kolkata to refer the representation submitted by the petitioner on 18th of April 2026 to the chief engineer or divisional railway manager, as the case may be, and the competent officer decide in accordance with.
Grateful, Lordship. The principal chief engineer. Respondent number 3, my lord, is the respondent herein, my lord.
Or any competent authority.
Or any consent. My lord, may I take back that or you review, your lordship? Grateful. My lord, may I pray one thing, my lord? It is time frame, so I can time frame because everything has been stalled. Yeah. As early as that, I can pursue the authority there.
They will say.
Grateful.
Yes, next.
Grateful. Grateful.
So happy for the petitioners. This is kept today for the enforcement director to respond to that limited issue. Because our Lordship had pointed out, you're covered by the Calcutta High Court Judgment Division Bench. So we thought.
Yes, madam, what is your instruction?
My
Position, so ये था reaffirmed copy वापस.
Their contents,
my
bank has already.
My lord, I am a late entrant into the matter, but my lord, I have made myself well versed with the matter. Lordship, our affidavit in opposition. My lord, we are recording the reply. I suppose they have already filed. Lordship, just before my lord, I don't want to cut a sorry figure before your lordship, but my lord, just as my lord's officer, I'm trying to indicate one thing subject to fearlessness granted by my lord. That my lord, there is an order of the Honorable Division Bench. This writ petition was filed in 2020, Lordship 1.
2021.
Lordship subsequently thereto, in 2024, the Honorable Division Bench of this Honorable Court had passed an order that all matters relating to Rose Valley will go to the Honorable Division Bench, which is taking up the Ponzi matters, my lord. Now, my lord, this is also relating to those group of matters of Rose Valley, because it is arising out of one of the parties, which is Rose Valley. And in fact, Rose Valley had transactions with the petitioners herein, and that gave rise to attachment of this particular, and the attachment impugned. So, my lord, that judgment is there, my lord. If my lord may have a view, and then my lord, if my lord takes up, my lord, I am going to argue the matter. Just because, my lord.
Order recording the division bench.
A copy can be given to us.
Yes, I have already given it to your learned junior, sir.
Division bench has opined that it's
Google it also. I don't research from perfect.
Yes.
Lordship,
Would
another.
your Lordship allow me to just read the order?
Honorable single judge of this. No,
They are single judge. Where is the division bench order?
Well, division bench order. But we could not. But my lord, that is
referred here.
Yes, my lord, that is referred. And accordingly, my lord, this matter was transferred to the Honorable Pontiff. Now, my lord, if my lord, so because my lord, I was a late entrant and this was not pointed out to my lord at the very outset, my lord. So therefore, if my lord so deems fit and proper, my lord, I may place my case because my lord, as far as I understand, my lord, they have argued on 2 points, my lord, that initially that provisional attachment order, which was passed, that is subsisting for 180 days, and in between that particular period, either confirmation should be given or my lord, whatever decision the adjudicating authority needs to take, my lord. Now, my lord, the only point which I intend to argue before your lordship is whether we come within the ambit of that amnesty given by suo motu writ petition 3 of 2020 by the Honorable Supreme Court, where, my lord, and whether that is applicable to Enforcement Directorate. Now, there are, my lord, judgments, my lord, which say that no, Enforcement Directorate is not covered. The actions by the adjudicating authority or the procedure is not covered by the Honorable Supreme Court's that amnesty judgment. But, my lord, subsequently, recently, Telangana High Court, Karnataka Lordship, in 2026 March has come that no, we are covered by that. And prior to that, the Honorable Division Bench of Delhi High Court is also holding in our favor, where the Honorable Calcutta High Court's judgment was also taken into consideration. Now, specifically, because there were a series of orders which were passed, one which is being relied upon by my learned senior friend, or my adversary here, maybe not taken into consideration, but that aspect was taken into consideration. So, my lord, if my lord so deems fit and proper, then my lord will take up this matter. Then, my lord, I will place my argument.
No, if there is a division bench order, it has to be placed and it has to be, the matter is to be released from this court.
My lord, that.
I only just say this. I don't think that this single judge order seems to suggest that all matters, only those which are connected in that group are to be placed before the DB. I don't think there's an omnibus order of the division bench that anything and everything is to be sent there. Now, Rose Valley is not a party to my petition. This is a very simple issue regarding the question of law, which is covered by the division bench of the Calcutta High Court. That judgment was carried to the Supreme Court. Supreme Court has affirmed the division bench of the Calcutta High Court. So, therefore, the question about now looking at Telangana and Delhi may not arise, and certainly Calcutta is now binding. I mean, also then add that so far the division bench of the Bombay High Court is concerned, it not only considered the Calcutta High Court and followed Calcutta High Court, it considered two other judgments of the Supreme Court, including Vijay Chaudhary, which considered the question of the virus of the PMLA Act. And relying on the various observations in Vijay Chaudhary, while interpreting Section 5.3, has come to the same conclusion as the division bench of the Calcutta High Court. Now, Delhi High Court did not agree with Calcutta High Court, but Calcutta High Court is binding and it went to Supreme Court. Supreme Court has not interfered in the Calcutta High Court judgment. Now, therefore, now that issue is binding so far as our court is concerned. And therefore, as I told your lordship fairly, that so far as provisional attachment is concerned, may be set aside and the lien be lifted. There is another judgment of the Supreme Court which dealt with the question of whether an adjudication is maintainable, and that is against me. And I placed that judgment to before your lordship. So far as adjudication is concerned, I will be relegated back based on the Supreme Court judgment, and I'll take up all my contentions on merits before the adjudicating authority. But what has happened here is that the asset has been attached from 2019, and after in our matter, the single judge of the Calcutta High Court also held 180 days. The provisional attachment order expires. After that, we wrote to the Enforcement Directorate on several occasions and to Yes Bank, please release the monies. Till today, they did not release the monies. Hence, we were compelled to come back to the court for the declaration that the provisional attachment is bad and that Yes Bank be directed to release. Now, Yes Bank doesn't have a difficulty in releasing the monies. So, monies may be released and then we may be relegated back to the adjudicating authority, and no prejudice is going to be caused to the department, since I am not here asking for quashing of the entire proceeding anymore. Though it was there in my original prayer, but I have now, Supreme Court has held against me, so I can't now go back on that. So I am only requesting that your lordship may find a way to resolve this limited issue. That's why on the first day I pointed out, there are only two issues I raised. One is on the adjudication authority, one is on attachment. Attachment I've succeeded, adjudication I've failed. And no prejudice is going to be caused to the department because I'm going back to the department on questions of merits.
You are having the bank affidavit?
Yes, and the bank's affidavit, they've said they have no objection, they release.
The bank, what I learned from my learned junior is that the bank has not served the affidavit on us. One. Secondly, lordship, the judgment which my learned senior friend is relying on, the Honorable Supreme Court's judgment, was not placed. What was placed before your lordship was that 2022, our Honorable Division Bench judgment, where maybe which relies on the Honorable. I may, my lord, in this particular circumstances, my lord, there cannot be any straitjacket formula. So, my lord, what I'm humbly submitting, if my lord gives me a breather of 1 day, 21st November 2024 order, which has been passed by this Honorable Court with regard to Ponzi matters, because this is a judgment which was passed in 2024. So, my lord, after considering that judgment, if my lord intends to take up the matter, my lord, I have no issues
No,
with
that's why, no.
So, my lord,
They
that
are only,
judgment,
their contention on the last occasion, no, today also, if you go to the paragraph 11 of the bank has given an affidavit that the respondent number 4 is ready and willing to remove the lien on the account of rupees 11 lakh, which has been attached.
Yes.
Correct. So if they are telling that the bank is ready and willing, so now only with regard to the adjudicating authority.
That's
So with regard to the adjudicating authority, is telling that with regard to the adjudicating and let the matter remanded to the adjudicating authority, they will take decision in accordance with law. It is the prayer which they are making before.
my lord, adjudicating authority being remanded back, my lord, I cannot have any qualms to that. Because, my lord, I also want that adjudication to be done by the adjudicating authority being enforcement directorate. But, my lord, if in the meantime, because the bone of contention before your lordship was, my lord will kindly give me 1 minute, my lord, I'll conclude that. One, my lord, we had made the attachment on 31st of January 2020. Subsequently, thereto, in the month of April, they filed a writ petition challenging that particular action. That writ petition could not be heard. And, my lord, because the intervening COVID period intervened, subsequently thereto, they did not even, several summons were sent by the adjudicating authority, but due to the COVID, they also prayed for time and the matter lingered in that fashion. Then, lordship, after 180 days expired, they came before this honorable court and said that we are withdrawing our writ petition on the ground that now that writ petition is not required because 180 day and there's a bar. And so we, lordship, we oppose that prayer, but it was recorded by the honorable coordinate bench that yes, that period has expired, but then nothing was made. No such observation was made, which will take away my case that it does not come within the ambit of that amnesty order passed by the Honorable Supreme Court. Subsequently, thereto, my lord, there have been judgments which were passed by the Honorable Division Bench of this Honorable Court, and subsequently, this order which is before my lord, that all matters will go to the Ponji, and subsequently Delhi High Court in 2025 and Telangana High Court in 2026 March. Now, lordship, here, my lords, before my lord, we have three contentions. One, the 2022 judgment which has been cited by my learned friend, where he has taken a plea that judgment was passed, taken into consideration the Honorable Supreme Court's judgment and also the judgment of the Honorable Supreme Court in other matters. Now, my lord, these two judgments which we are citing before your lordship also take into consideration various aspects. What I am humbly submitting to cut the matter short, let us exchange the judgments, come back to my lord tomorrow or maybe my lord on Thursday, and my lord, and with this judgment. And first point, my lord will see that whether this particular matter comes within the ambit of the division bench judgment which is there before my lord. And then after that, if my lord decides and my lord will take it, then we will sort it out as far as these judgments are concerned, my lord. Because then only on technical point of law. But my lord, if my lord, now coming to the question which fell from my lord, that if it is redirected there, that the adjudicating authority, but in the meantime, if they take away the money, the attachment is removed. What I'm humbly submitting is if they let there be a breather of maybe 30 days where the attachment may not be removed, and in that particular breather period, they may file their show cause and we may, adjudicating authority may adjudicate. Then if they show that it does not form proceeds of crime, then, my lord, the adjudication authority will take appropriate decision, which will be binding on me and them both. But, and then, my lord, need not decide whether it comes within the ambit of 180 days or not, my lord. Then there can be a consenting order. You know, this is what I'm humbly submitting before your lordship and also for the audition of my senior
So
friend.
you do one thing, whatever the judgment, you serve the copy to the other side.
We'll serve them a copy because all these issues have been considered. The Supreme Court also, while dealing with the question of that the education will continue even if the provisional attachment is set aside. So all this has been dealt with. That's why I'm fairly making the statement. Otherwise, a lot of these issues have been now dealt with and disposed of.
What has fallen from your lordship is well justified, lordship, because my lord, if it is remanded back, it will be a situation where we both will be benefited. There will be an adjudication because we want an adjudication to be done by the adjudicating authorities. So, my lord, if it is remanded back, then, my lord, this question need not be decided as if we come within the ambit of that judgment.
With regard to the
only point where I am trying to join issue with my learned senior friend is this, lordship, that if in the meantime the bank releases the attachment, then, my lord, even after the adjudicating authority comes to a final finding, it will become difficult for us to retain or regain that particular attachment of 14 crores and odd which is lying.
11
crores. I stand corrected, Lordship. I'm a new entrant, Lordship. I tried my.
You exceeded 3 crore further.
But I'm sure that my learned friend knows the long arms of the PMLA, as the whole country knows. So nothing goes away from the PMLA. They'll always find a way if they want to. Not as 11, they may even get 14. I don't know. But this
Okay. Let you consider this judgment and whatever the judgment is before this court on the next. Counsel for the ED has relied upon the judgment passed by the division bench of the Delhi High Court and the judgment passed by the Telangana High Court and the judgment passed by the Honorable Division Bench of the Telangana High Court. After serving its copy and copy for the petitioner, let the matter appear. When? Day after tomorrow?
Would your Lordship keep it on Thursday?
Thursday, sir.
Let the matter appear on 18th June.
Top of the board? Would your Lordship keep it top of the board?
18 under the same heading within 5 matters.
I'm grateful.
Affidavit in opposition filed by the respondent of 1 and 2 be kept with the report. Great. Next.
I am appearing for the writ petitioner. My lord, in this writ petition, my lord, I have challenged the actions of the respondent bank in classifying the petitioner as a willful defaulter. Now, my lord will see that the petitioners before my lord are 4 individuals.
What are the grounds?
My lord, grounds. First ground, my lord, is that no order of the identification committee was ever served on me. For me, there is no such order in existence. I had in fact filed a prior writ petition challenging on the same point. By that time, my lord, the bank had issued a notice directing me to appear before the review committee. My lord heard the writ petition. My lord said an opportunity is being given. You take all points before the review committee. My lord, pursuant to that order, I took all these points, my lord, which I had taken in the earlier writ petition before the review committee. Thereafter, again, the review committee allegedly has passed an order which we have not seen. What we have been given is a communication of the order passed by the review committee. Till date, my lord, even when one goes before the review committee, my lord, I'll have to challenge the order passed by the identification committee, why it should not be sustained. My lord, though that identification committee order has never come to me. Even if the communication which has been given to me lastly, my lord, where the review committee as particular order and a date has been mentioned, but I have not been given. My entire cause of action, my lord, I'm led by Mr. Bose, my lord, kindly grant sleep. আমি জাস্ট এই ব্যাকগ্রাউন্ড বলেছি, একটা পাতা কিচ্ছু দেখায়নি, শুধু ওই আগে একটা রিপিটিশন হয়েছিল ওইটুকুনি বলেছি। কমিটির অর্ডার আমি পাইনি, আইডেন্টিফিকেশনটা বাইরে অর্ডার।
Well, strangely enough, as your lordship recollects, we've been about several matters of willful defaulters. Well, jar developer read with the master circular is the law. So there are 2 things jar developer says. Well, it's a 2-tier process. Well, first is once a shukos is issued, the shukos is to be issued by a identification committee constituted in accordance with the master circular. Number 1. Number 2, once a shukos notice is issued, well, the alleged an opportunity to file a representation. Once that representation or objection is passed, it becomes under the circular and jar developers, para 24, it becomes an obligation on the part of the identification committee to part a reasoned order. Once order is passed, communicate. So then my right is to make a representation before the review committee. So that's the second stage. Then the review committee has to assess whether the recommendation made by the identification committee is required to be affirmed or rejected. So this is the entire process. Now, my lord, here I'll just apply those principles to the facts of this case. Here what happened is, shukos issued by a person who does not form a part of the committee constituted under the master circular. Number 1. This is my first infirmity that we complain of. Number 2, once the shukos is given, I give my objection. There is no order of the identification committee. No order. A person who claims to be the assistant manager of the bank, he passes an order. So we don't consider that to be order of the identification committee because this is not in accordance with the master circular. Then we file a writ petition. Writ petition is heard. Now an interim order is passed directing the bank to file a report to show whether the identification, because that was at the identification stage, whether the identification committee was properly constituted or not. Report is conspicuously vague, does not indicate anything, also does not say that this is the order of the identification committee. So at that stage, when the writ petition is disposed of by your lordship, your lordship says that take all these points to the committee. But I go before the review committee, I take these points. But interestingly, despite the previous writ petition or previous order of the writ petition, none of the points taken by the lordship's order, we don't even know if it is being considered or not. Order of the review committee in terms of jar developers.
So what your challenge here?
Challenge question that I have received refers to the order of the review committee.
Communication made by?
Communication made by, my lord, the general manager. My lord, kindly see it's a communication of 2nd May by the chief manager. It's a communication by the chief manager where he refers to an order of the identification. My lord, kindly come to page 279. If we go backwards, page 279. My lord, kindly take page 279. My lord, kindly take
Yes.
My lord, if your lordship will see this refers to 4 persons, then my lord, kindly take the account number such and such, the names are given, you have availed such and such, then kindly come to page 280. Due to non-payment of installment interest, the above account has been classified as a non-performing asset. Further, 280. Further, you have also been declared as a willful defaulter by the bank on 23rd of March 2026. Despite reminders and recall notice, you have not regularized, adjusted the account.
So where is the order dated?
No order till date. Now, so your lordship, first thing is that how are you agreed? If there is no declaration, so there is a declaration. Now you have to satisfy. So this matter, kindly come to your lordship's order. In my previous round, when we filed the application, my lord, kindly come to page 267. My lord, kindly at 267 is the final order by which the previous writ petition was disposed of. And at that point of time, we were at the stage when we were complaining that there is no order of the identification committee, not constituted properly, no order. Apropos this, my lord, kindly take your lordship's order at page 267. Para 2. This court finds that the bank has issued the show cause notice on 24th of April, calling upon the petitioners to file their objection as to why the petitioner has not been declared a willful defaulter. On receipt of the show cause, petitioner has submitted a reply to the bank, and the receipt of the reply, bank by letter of 12th of July 2024, my lord, kindly 25, informed the petitioners that the representations submitted by the petitioners are not satisfactory, but the bank has not, my lord, kindly make a note of this, my lord, passed any order by declaring the petitioner as willful defaulter. So with the 12th July, because we say it's a communication, this is not an order by the, if your lordship wants, I can give your lordship exactly where it is. That is at page, 12th of July is at.
Yes, continue.
Yes, my lord. Then kindly take the next paragraph. Now the bank has issued a notice to the petitioners for personal hearing on 12th February, directing the petitioners to appear before the review committee on 27th of February. This court finds that the bank has not taken any final decision, and still the bank is giving an opportunity of hearing to the petitioner, and notice has been issued to the petitioners for personal hearing.
Thus, this court is of the view that if the petitioner is given any grievance, petitioners are having any grievance, either with regard to the authority of issuance of the show cause notice, so Lordship has given me that liberty, authority of the issuance of the show cause notice. Number two, notice dated 12th July, and the committee who is holding for personal hearing, the petitioners can raise all the points before the committee, and the committee is entitled to take appropriate decision on the submission of the petitioners. Now, my lord, kindly take my representation based on your lordship's notice. Immediately after the order, kindly take page 269. I'll just give you a lordship, my lord. What are the points that we had taken? My lord, at para 11 at page 270, I had taken the point that the willful defaulters committee was not validly constituted. Para 11, para 14. So kindly take para 14 at page 271. May I, your lordship has para 14. Okay. It was stated that the show cause notice issued by your authorities is not in accordance with clause 3 of the mechanism for identification of willful defaulter of the Reserve Bank of India Master Circular on willful defaulter, such and such, and is issued for the sole advantage of the bank. Such notice is arbitrary, discretionary, undemocratic, such and such, and lacks objectivity, void ab initio. Then, my lord, kindly take para 16. Without paying any heed to the maintainability of the show cause notice, which we had agitated in a reply of second authorities on 12th July, you had proceeded with the instant matter and stated, however, based on available evidence, such and such. Then, we refer to the writ petition filed by us. Then, my lord, para 23, we say at page 272 that the identification committee, that the notice of 12th February totally bad in law, as the previous notices issued with regard to the identification committee is bad in law. The not constituted notices are bad. Then, my lord, clause 3, I refer to the master circular clause 3. Then, my lord, para 25. Then I say that these two notices issued by the identification committee are non-est in the eye of law. No jurisdiction, therefore, for the review committee. So, my lord, without there being an order of the identification committee, the review committee would not have jurisdiction. So, review committee will consider the order of the identification committee. If that goes, then there is no review. So, this is the point taken by us. Then, my lord, kindly take 274A, which is the typed copy. I humbly submit before your authorities that as of today, there is no such order of the identification committee. Therefore, the said review committee cannot proceed with the hearing as fixed today on 27th February. Now, my lord, apropos this, my lord, kindly take 12th July once, my lord, because we are saying a lot of things about 12th July. I'll just trouble your lordship once with 12th July. Page 170. My lord, this may be a little illegible. Typed copy. Page 170, typed copy.
No, here is the
Legible. So, your lordship, naturally, judges are always privileged. We are not.
After all, give the justice.
Yes, of course, of course. But we are also here to assist your lordship to give that justice. So how do I give assistance? My learned friend is also better placed than me. But kindly see এটাকে কি বলে? The reference ballot, declaration of whole time directors of deal such and such as willful defaulters. That's sufficient. Now kindly turn straight away to page 174. We have a lot to say on merits.
Yes.
Well, apart from the fact that the events does not even contemplate events of default under the master circular, I am not saying, I am not agitating this for the time being right now. For the purpose of interim order, I am just showing you lordship prima facie. Well, kindly come to page 274. So even assuming that this is the order of the identification committee, because they proceed on the basis. Now, my lord, your lordship is seen under the master circular. Who constitutes the identification committee is the executive director plus two officials, which is either the general manager or the deputy general manager. This is the constitution of the committee. Now kindly come to page 274. Kindly see who is issuing this alleged 12 July declaration.
270?
174. I showed your lordship 12 July. It starts at page 170.
Yes.
At page 174 is the person who signs the order.
Assistant General Manager.
Assistant. So, my lord, under the master circular, my lord, your lordship is aware, my lord, the constitution is executive director and two general manager or in the category of deputy general manager. So, he is none.
Where is the constitution order? You are having the order of the constitution of the committee.
I come to your lordship. Now, when we challenged it, they filed the report before the previous writ petition. Show you from the report today. My lord, kindly take, now my lord, apropos this, my lord, kindly take the report that they filed in the previous writ petition. My lord, if your lordship takes page 220.
Yes.
Your lordship will be surprised to note there is not, this was a specific challenge in the previous writ petition. Your lordship is recorded while disposing it of. Kindly see the affidavit. Not one word on constitution of the committee. Now, what they have done is, instead of making any pleading, I'll give them that benefit as well. They have annexed a few documents. Very well. Now, my lord, kindly come to the documents. There is one pleading at para 15 at page 233. 233 para 15. The respondent makes, this is a part of the report, seeks leave of this honorable court to rely on both the above mentioned circular and the bank guideline on the basis of the circular. In the instant case, as per the advice of the identification committee, dated, my lord, kindly make a note of the date, 1st of April 2024, the assistant general manager, such and such, had issued a show cause. So this is there is no better evidence than admission. So the circular does not contemplate that you can delegate the authority to issue show cause. So it fails here because they say the identification committee has advised the assistant general manager to issue the show cause. But pausing here for a moment, is that permissible under the master circular? It is not. The judgment of Atlantic in our court coordinate bench holds good that there is no power of delegation. Now, my lord, kindly see what they rely upon based on this report is a, my lord, is a communication which they refer there. It's at page 241, which is a part of the report. It's your lordship will find it's a communication of the bank of 16th January 2024. Relevant portion.
Recommendation. If your lordship will see, who writes this letter? Note of ED committee for examination of willful default angle. My lord, page 241 top.
Yes.
Examination of willful default angle in the account of fair deal supply. My lord, this is the borrower company, of whom I was a whole-time director. Then, my lord, kindly see at page 244, there is clause 4. It refers to department recommendation.
Yes.
So then at page 245, your lordship will find this alleged recommendation has been made, submitted for approval, please, and these are the signatures of the individuals. So, my lord, if your lordship will, let's take the bull by its horn, even assuming, give them all 100% benefit, public sector bank. Kindly see, chief manager law, assistant manager law, assistant general manager LNR, general manager LNR. Now, my lord, apropos this, my lord, kindly have a look at the constitution of the, just, my lord, pause here for a moment. Though there is no power of delegation, even assuming, my lord, kindly see the constitution in terms of clause 3, which is a part of page 62. I'll just read it out. It is there, master circular we've annexed, page 62, clause 3 of the master circular.
Yes.
3A. Evidence of willful default on the part of the borrowing company and its promoter, whole-time director, at the relevant time should be examined by a committee headed by executive director. Let's pause here for a moment. At this page 245, at that page 245, did your lordship find any executive director? Your lordship will not find any executive director. So even the alleged recommendation made was by a committee, even if there is assumed to be one, is not in accordance with the master circular. Now what it happens, if your lordship calmly comes back to 242, page 242. But if your lordship now kindly comes back to 242, I have lost it. Kindly give me a moment. 244. Now, my lord, that part of the report, page 244.
Recommendation.
Yes.
Department recommendation.
Yes. Report filed. Yes, I've got it, my lord. 241. My lord, kindly see the next document. 249. No. 246. I stand corrected. 246. So one, that recommendation advice to issue was also given by 4 persons who does not form a part of the committee. Now 246, which is also a part of the report filed in the previous writ petition, 246, is the letter of 1st April, which was referred by them in their para 15 of the report. Now kindly see this. Page 246. Permission to issue willful defaulter show cause notice to the borrower. Well, kindly see the signature at page 248. So they have broken it. So they have restructured and rewritten the master circular themselves. So 246 is a permission which has been given to the assistant general manager by the assistant general manager. At page 248, your lordship will see one assistant general manager is writing to the other assistant general manager.
Yes.
And my lord, kindly come to the show cause notice, which is the subject matter of the present writ petition, page 51. And my lord, kindly see who has issued it. Page 51 is the show cause notice, volume 1. And my lord, kindly come to page 53.
Yes.
You will find at page 253, Assistant General Manager. So you have no authority to issue the show cause. Atlantic parada bar karo. So now, my lord, again, my lord, thereafter this was under challenge before your lordship, nothing. So then I went representation. Now, my lord, if your lordship will kindly come. My lord, just apropos this, my lord, I'll just show your lordship one paragraph of the Atlantic judgment. Because if the show cause is bad, if the show cause is issued by an authority which doesn't have jurisdiction, everything fails. So
that's why now that where is the constitution of the committee of the identification and review committee? You are having the order. Yes, madam, you are having the order with regard to the constitution of the committee of the review committee as well as the identification committee. Where is that? 249. Where is the committee? 249. Yes. This is the identification.
And to general managers as per that.
Correct. This which is this identification committee? And where is the review committee?
No.
This identification committee. And they have identified the particular account appearing in page. Examination of angle of principal default in account of. So all this submission was there was no proper identification committee as per law and as per the submission. But my lord can see one ED and two general manager as per the circular. The identification committee was formed at the request of the concerned branch for examining the angle of principal default account, including other accounts which we are not concerned. My lord, the particular account.
No, then you, if it is the identification committee.
Yes.
249. 249 identification committee. Executive director, no problem. General manager and general manager credit. And convener is the Subhash Chandra Sagar, assistant general manager LR. Correct. So he is the convener. So he conveyed the meeting and as per the direction he may issue the so-called notice, whatever it may be. Now you come to the page 53.
My lord, without troubling you, my lord, kindly see page 261 of the same document. My learned friend showed 249. That is your minutes. Kindly see that same minutes is signed by whom? So even if it is assumed that the three names are there, those three people have to pass an order. Where is the three persons reasoned order? And this order is at page 249, which ends at 261, is again by the assistant general manager. Where is the executive director?
Here.
Convener was the assistant general manager.
Correct.
But below that, the general manager and general manager credit.
Yes.
Signed the order.
Correct.
And the executive director, Ramjas Jadhav, he has also signed the order.
Correct.
Atlantic to the.
Fine. Whatever point, my lord, this is your query fell from the lordship.
No, now come to page 53. Who has issued the so-called note?
Correct.
Ah, 53. Their so-called notice.
আমি যে আগের দিন কালকে আমার briefing
After the identification committee, then the so-called notice is to be issued. Correct. The so-called notice is issued. Can you see who has issued the so-called notice?
প্যারাটা বলুন।
Correct.
ও সুধীর পাটোয়ারি, sorry, Atlantic-টা দাও।
The order
But-
has been passed
No,
formally.
Atlantic
will
be 18:30.
Correct. But you are having the convener. You are having the convener. So why the assistant general manager has issued the so-called notice?
Atlantic-টা কোথায় গেল?
Why the assistant general? What is the meaning of the constitution of the meeting, committee?
31, 31.
Committee has recorded. Then all the things is to be done by the convener. Correct. So why this assistant general manager Sambert has issued the notice?
As it appears from the record, you will ask me.
Why? What is the circumstances? You have to go by the law.
As per law, or the committee has been formed, order has been issued by the committee, everybody has signed the order. And then the communication to the party has been made as per the committee.
So kindly come to the page 53. This communication is issued as per the direction of the identification. Where is the direction of the identification committee?
কোন জায়গাটা বলো? আমার Atlantic-টা কোথায়?
Direction. I got clearly here. I will rely on the same report which we have filed in the earlier petition on the same ground. And we have showed that he has been directed by the committee.
And where is the committee of the willful default of this review committee? Where is the review? Where is the review committee?
My lord, I will.
In the review committee, who is the convener?
My lord, I will.
If I find the convener is the same person, I will set aside the whole. My order is there. I find that the same convener has been given to the both committee, then I will set aside the order. And my order is there. That's why I want to see the willful committee, the constitution of the review committee. If the review committee, the convener is the same person, then it will be difficult. And you have to satisfy
last day যেটা আজকে আছে
and you have to satisfy with regard to this communication has been issued as per the direction. Where is the direction? Who has given the direction? Because the 261 does not reveals that. Correct. The order is, yes, where is that?
Have filed the report, we will rely on the same finding in the committee. And on the report, the whole report has, I have to come back with the report what we have filed in the form of that.
Oh, entire report has been annexed. Half report annexed করেছেন। This is the report. Entire report has been annexed. This was filed before the court in 2025.
Necessary document as directed by the lordship.
And my lord, the order of 12 July also passed by the same assistant manager, not by the willful defaulters committee. That 12 July, yes.
Because the similar matter was came up before this court, and this court find that constituted the committee. And the same what you have raised the question, issuance of the notice by the assistant manager. So then they have taken the plea, he is the convener. And I find that the convener in both the committee. So I set aside that and remanded the matter. It cannot be.
Correct, absolutely, cannot be.
And if the convener is there, but so why you are giving the
PCI.
task to the assistant general manager? Not satisfied. What is the duty of the convener? Is also the assistant manager.
29 Kollu.
When you will come? And what your challenge, Mr.
Yes, now, my lord, we had mentioned, if your lordship, 2 times, why was the urgency? My lord, kindly take once section 29A of the insolvency.
Where is the impugn order?
Second May, because if your lordship, I started by saying, by referring to the first communication of 2nd May, which is there at page 279, which refers to the order of the identification. Executive, I stand corrected, the review committee, but there is no order communicated to me, the review committee. And they maintain the standard you are a willful defaulter. Now, what is the consequence? Well, I have given your lordship the copy of the insolvency and bankruptcy code. Kindly have a look at that. I'll tell you, lordship, what has happened. Now, the principal borrower company is in CIRP. Now, since it is a MSME, even as a promoter director, I am eligible in law to make a resolution plan. So I am a prospective resolution applicant.
Yes.
Well, kindly section 29A. Now they are saying the committee of creditors are whom? The present bank is the committee of creditors. They are saying you are a willful defaulter. We will not consider your proposed resolution plan. Kindly see 29A subsection B. So this disqualifies me if I am a willful defaulter. 29A, persons not eligible to be a resolution applicant. Kindly take B. A, it starts by saying, it reads as follows, my lord. A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person, B, is a willful defaulter in accordance with the guidelines of Reserve Bank of India. Now, my lord, kindly have a look at the supplementary affidavit that we have filed. Supplementary nahi lega. But we've served upon them a supplementary. Judge Chef ke dao supplementary ta. My lord, we've been filed. My lord, kindly take page 113. Page 113. Well, it starts, this is the form G, which is published for the purpose of submission of resolution plan. Well, kindly see, yes, supplementary service code. Well, kindly take serial number 13. Date of issue of final list of prospective resolution applicant, Monday, 15th of June. So I'm ineligible. So because of this process, I become ineligible. I cannot participate.
Yes.
So well, that's why I'm asking. That was the urgency. Well, at least I have some hope today. Today is the 15th. If your lordship stays the declaration of willful defaulter as a willful defaulter, then I can go back and tell the resolution professional that you consider my plan. Because if he publishes the list, today is the last day.
What will happen? Okay, today the court will pass an order for stay of the impugn.
Yes.
Declaring you a willful defaulter and the resolution plan is admitted.
No, not admitted.
Submitted.
Submitted.
Submitted. And at the time of hearing, if it is filed, there is no defect in the willful default.
Very well. Very well. Then I go. Suppose 10 persons come. I am one of them. Now it is a process. This is the last date. After the submission of the resolution plan by the prospective persons, they will be considered by the COC. Now I am ineligible. I cannot be considered today. Now, if the consideration process is on, and then eventually I am found that yes, I am a willful defaulter. Suppose your lordship finally holds that yes, you are a willful defaulter, everything is in order. Then I go, the others will be considered, so other plan will be approved. My plan will not be approved. I become ineligible. But I cannot even today, I cannot even enter the race. I cannot even enter the fray because I become statutorily ineligible. That is the problem. And that, my lord, they have already, basically it's a stratagem to keep me out. That I didn't want to trouble your lordship. We've annexed the minutes as well.
Yes, madam.
And prima facie, my lord, based on paragraph well, and just one paragraph of Atlantic, my lord, just for your lordship's consideration, para 31, my lord, this is settled by this court. What they are saying that assistant general manager was authorized to issue the show cause. That cannot be. That's not the my lord, the scheme of the circular. My lord, kindly take para 31, about 4 sentences from the top. Issue of show cause notice is an integral part of the decision-making process in the issue prescribed to be decided by the stipulated decision-making authority. In the scheme of the decision-making process, as prescribed under the subject master circular, in my view, the function of issuance of the show cause notice cannot be delegated.
And this willful departure notice has been issued by the chief manager.
Assistant general manager, page 53.
Page 80, 280.
Yes.
It is issued on chief manager.
Yes.
All the chief manager is the who?
Nobody.
He is the committee member.
No, he's not.
Or it's not a convener also. Neither is a convener. And it is not.
Keep tick.
Can't we?
And today, my lord,
So that's why the committee is not issuing the notice. Your convener is there. Why you again giving to the bank? Why the committee? Independent.
For this issue,
Wait.
keep internal documents and.
But what about their application? It is to be submitted today, and as per it is bar under the 29A. Then what will happen?
Have to really submit that this is our total we have done because whatever we have happened with that. All that.
I have made out a primary case, my lord. My respectful submission, lordship stays the declaration. Let them file the report or in the form of an affidavit, so that I can, my lord, take your lordship's order and go before the resolution professional.
You can come back and automate. That's what I'm telling you. You come back if the court satisfied that you have done in accordance with law, then automatically a repetition will be dismissed. But as on date, from the prima facie record, it find that the committee is overall in charge, but he has authorized to all the persons to issue so cause notice, issue the defaulter notice, but the committee has not done so. He might have been taken that decision has to be conveyed by BAM, either the committee itself or by the convener. Then, but here they have given to the bank, communicate this. Have you gone to the judgment of the this court?
Yes.
Huh?
Why?
Correct. If they will submit. Correct. If they will submit this, if I. Correct. Yes.
Amount?
88 crore, yes. Correct.
Amount of
It is a recovery proceeding.
and we have done whatever as per our instruction, we have done it as per the law and circular. Now, my lord, this 15th, when we are going to issue the.
Correct. That will be decided. That's only the question now with regard to the prima facie. You have to act in accordance with the law which has been provided to you. If you are avoiding that and passing an order by issuing the notice by some other person who has not been authorized, how the delegation can, even delegation you cannot make. How you can say the assistant manager to issue the notice, the chief manager to issue the notice of default. Defaulter has to be decided by the committee itself.
And there is no order by the identification committee. 12th July is order by assistant general manager.
The order has been with the identification.
280, kindly
Where?
come to the 280.
Where?
There is no authorization. Who has given the authorization to the chief manager to issue?
It has to be communicated to me.
All along, all the reasons order that why he has been considered for as and why every time he has been given chance to review and with the notices he has not reviewed, he has come up with a reply.
So how soon he will come?
Baba.
As your lordship, sir,
Come tomorrow?
will be very short, my lord. We have to bring all the papers from.
Which bank? Punjab Sindh. Where it is?
For this willful default, it is lying in Delhi.
The lordship previous order is not challenged by them, which specifically records there is no order of the identification committee. And I'm showing before lordship there is no order, page 174. The order was they claim to be the order, that is also by the assistant general manager. So where is the order?
Done by the identification.
Where is that obvious order? It did not form a part of your report filed in the previous rate. That is why your lordship said, take the point before the review committee.
Then it has to be straight. Willful default, it is to be straight. If you are not able to produce the document, you are asking 2 weeks time. Now, so, huh?
For showing whatever and whatever
Then, my lord, kindly stay. Otherwise, I will not be able to submit my resolution plan.
Pray for time. Pray for
No, my lord, time, because this is a published Form G under the regulation. It is a fine published Form G. If your lordship will see page 112, is a published Form G. Now, kindly see, my lord, he says the resolution process will get vitiated. Now, I am not the only applicant. There will be 20, 50 other applicants who will apply. I am one of them. So my lord.
Who has filed this? Petitioner.
Form G has been filed by the resolution professional. It has been published in the newspapers. Form G. So all I want to say is that I want to be considered. I become eligible, I will be considered. It's like a tender process.
The petitioner has filed the present
May I take your lordship? Kindly leave, my lord.
Challenging the impugned order dated 2nd of May 2026, wherein the petitioner has been declared as willful defaulter by the bank on 23rd of March 2026. Counsel for the petitioner, Mr. Managos Leonard, Senior Advocate, the petitioner, draw the attention of this court to the so-called notice dated 12th of July. Yes. Who will extend? How you will request?
Today is the last date.
You can request. You are not a party over there.
COC member, he cannot, they cannot. COC, they cannot. There is a bar in law.
But it is published. It is published. Today is the last
And
day.
it's a committee of creditors, my lord. They are not the only member of the committee.
Correct.
Is the other creditor object? How?
Okay, that's why I am asking.
Lord, if that request is not accepted, my lord, then my last date goes automatically, my lord.
So that's why let you come with them
Yes,
for
for
a
a
week.
limited
The time be extended for a week.
Limited period.
Let the time be
order, my
extended
lord.
for a week with regard to that.
My lord, there is no.
But today is the last date, madam. Tomorrow you are telling if the COC will not accept, then what will happen?
And my lord, the COC may reject also this
That's
request.
why what will happen?
A limited period in.
What will happen? When this notice was served to you? When the notice of this writ petition was served to you?
Filed on the 20th of May, my lord.
22nd May. 22nd May you received. Why you
22nd
not got all the instruction? He has taken all the summer vacation. After summer vacation, 10 days has passed. Okay, whatever. 3 days, but what will happen to this?
Not to consider.
No, if the COC will not consider your request, what will happen? Because you are not. Maybe you one of the member, but what about the other?
The other member of this.
What frustration? Correct. Correct, but once you received in the month of, why you not taken the instruction when the matter is fixed today?
My lord, the only effect would be I would be considered eligible today. Even after 3 days, I can be considered to be ineligible if my lord finally holds that I am in full default. But my lord will, unless there is an interim order, my lord.
Get it in. The Mr. Managos, Leonard Senior Advocate, appearing for the petitioner, submits that the so-cause notice, comma, so-cause notice, comma, the and the impugn order has been issued by the incompetent authority who are not the member of either identification committee or the review committee. Mr. Bose further submit that Mr. Bose further submit that one of the suspended board of director of Fair Deal Supplies Limited
Page 59, para 2.
Limited had submitted an application under section 7 of the Insolvency and Bankruptcy Code before the National Company Law Tribunal, and accordingly Form G has been issued and the date is fixed today for final list of the prospective resolution applicants. And Mr. Bose relied upon section 29 capital A of the Insolvency and Bankruptcy Code 2016 and submit that as per clause B of the said section, if A person is a willful defaulter in accordance with the guidelines of the Reserve Bank of India issued under the Banking Regulation Act 1949, comma, shall not be eligible to submit the resolution plan. Full stop. Learned counsel for the bank prays for time to take instruction and to place all the record before this court to justify that the competent authority has issued the so-called notice and the interim order. And he prays for 3 days time. She further submit that the bank is also one of the member of the COC and they will pay for extension of time for consideration of the resolution plan which has been fixed today. Full stop. In view of the submission made by the counsel for the bank, comma, the case is adjourned with the hope that the bank will inform before the to whom you will inform.
Resolution RP.
To whom you will inform.
Bank will inform the IRP.
Inform the IRP for taking the above matter. To IRP for taking up the matter today.
Page 114 IRP.
IRP, no.
IRP.
Resolution
That's
proposal.
RP होगा.
Yes,
RP. It is RP, you know. RP. RP not to take up the matter today as per the Form G issued for a week. In view of the submission made by the counsel for the petitioner, counsel for the bank, this court restrained from passing any interim order, but it is made clear that in spite of the undertaking given by the bank that the RP will proceed the matter for taking up the matter for admission of the resolution plan, comma, the bank will be responsible for the same.
I'm grateful.
Let the matter when you will come. Let the matter appear on 23rd on 23rd March and June 2026 within 5 matters.
My lord had given the interim protection for 7 days, my lord. 23rd we would be on the 8th day. So if my lord can make the 7 days 10 days, my lord.
19th.
I'm extremely grateful to my lord.
Next.
Well,
I am for the petitioner, my lord.
but I'm coming up.
My affidavit of service, my lord. I served up. There was a leave granted by this court for a short service, my lord. I've served upon all the respondents, my lord. Union of India and the Enforcement Directorate.
Yes.
My lord, today I am here before your lordship. The petitioner is a 76 years old person who in the month of May had a post-rate operation and was subsequently also admitted after filing of the writ petition. My lord, a notice under section 52 appeared before the Enforcement Directorate office in Jalandhar has been issued on 26th of May.
Where is the notice?
My lord, 26th of May notice is at page 23, my lord. Is that to appear on 2nd of June. This notice was received by me on 2nd of June at 4 p.m. The track report is at page 27. I'm not challenging the notice under section 50, the summons issued to me under section 50. I'm only praying today, my only prayer before your lordship is to take to ask the Enforcement Directorate to.
So it was received by you on?
Received by me on 2nd of June.
2nd June.
And 2nd of June is the date of my appearance.
Yes.
2nd of June at 4 p.m. I have received that, to be more precise. But I'm not on that, my lord. I have written an email to them immediately. They have responded to it. My lord, I have written an email on 2nd of June itself.
and to stating the same fact. And on 3rd of June, next at page 53 and 54, the Enforcement Directorate at Jalandhar had asked me to be present on 10th of June 2026. My only thereafter I write a letter saying that due to my old age, my ill health, that I have had an operation, and considering my situation to either do but I'll
So what has happened on 10th June?
On 10th June, my lord, I have written a letter on 8th of June stating them to my lord that kindly hold the proceeding via video conference or video conferencing or at the Kolkata zonal office because of my ill health, my lord. I filed the writ petition on 9th of June. The petitioner was, my lord, those documents are with me. On 10th of June, the petitioner was again hospitalized. My lord, I am not aware what happened on 10th of June. And I was discharged on 12th of June. My lord, Lordship will kindly take the summons for a moment, my lord. At page 23, it starts. Lordship will kindly take page 25. These are the documents that have been sought for by me, my lord, from me. Well, I can produce this document. I can produce this document electronically. But if they have to question me or whatever, my lord, the role, because the notice says that I have to give evidence. This is only for the purpose of giving my attendance is required only for the purpose. May I just place that portion, my lord? My lord, kindly will take page 23 for a moment, the last paragraph. Now, therefore, in exercise of power conferred upon me under subsection 2 and subsection 3 of the section 50 of the PMLA, I require said sham trading through its proprietor to appear before me in person at my office at the mentioned address on 2nd of June 2026 at 10 a.m. to give evidence in connection with the investigation or proceedings under PMLA. Well, I have to give evidence, my lord. Considering, my lord, I am ready and willing to go before the ED, but whatever evidence they want, whatever questions they want to ask me, I'm not shying away from that. But all I seek today is that considering my ill health and the medical documents already annexed here, my lord, let them do it via video conferencing or in the Kolkata ED office, my lord.
Yes.
But that is my prayer. I'm not asking for anything, my lord. And I am not aware, my lord. I'll tell you, Lordship, I'm not aware what has happened on the 10th. My lord,
yes.
Well, two things. First of all, this petition pertains to the summons. Because the player talks about the summons, then it has become infructuous. But however, his first prayer was at page 53 that reschedule it after 15 minutes. It was his prayer. He has not said that I cannot come. Page 53. And due to belated receipt, I cannot come today. The last sentence, I am requesting to grant short adjournment that may kindly be granted and the date of appearance may be rescheduled after 15 days. So accordingly on page 54, he was rescheduled on 10. Now after that, he made an email on 8th June saying his alternative prayers. Now first of all, 10th June has also gone. He has not appeared. There was no step against him. No fresh summon has been issued to him. Today we are on 15. No fresh summons, no fresh cause of action. This cause of action has died his automatic natural death. However, considering that he is an aged person and our investigation is not intent to harass him. Investigation is definitely at Jalandhar. He needs to go there because it cannot be done at Kolkata office. Well, because all offices are having separate jurisdictions and because tomorrow that may be an issue. We don't want to go into it. But if your lordship so desire, the lordship can allow him to appear through his authorized person with all the desired documents. But the authorized persons must know the facts, who can be an aid to the investigation. That much can I submit before your lordship that this has died, but in future, if he wants or if he is called for, he can appear to authorized person who is aware and who can be an aid. Somebody comes and say, I do not know anything.
Then again the question will come.
Same. That is why I am saying that let him authorize a person who
You
can-
appear.
My lord, my physical
When you are convenient day, you give, I will record that.
my lord, my physical health, my lord, I was admitted on
76. Now there's the business persons of 80s, 90s are traveling
lord,
to the foreign
my
country.
lordship will kindly.
You are going. It is a Jalandhar 2-hour journey.
My lord, the
Flight?
point, my lord, the point is two things, my lord. My lordship will kindly appreciate. It is not a matter of 2 hours journey being there, my lord. I have nothing over there.
What is the report? Can you see the report? Can you come to the page 50? Nothing. Nothing. There is nothing in the scanning.
No, my lord, he had gone and got through an operation that
maybe operation. That's why you tell me. I will fix the date. You go after 10 days.
My lord,
15
kindly
days.
lordship will see that I will, my lord, let them, my lord, I will provide.
Because see, ED or 3D, it is not the one person is coming with the file and investigate. ED is investigating with the group of the officials. For one person, the group of the investigating agency should not come
My
here.
lord, I have also had psychological ailments, my lord. I will humbly requesting, my lord, a comfort. My lord, let them do it through, my lord, VC. They can question me through VC. I will produce a document, my lord. These are the kindly lordship will see page. Kindly lordship will kindly see page 50, page 25, my lord. Kindly see the nature of the document sought for, my lord. Self-attested copies of PAN card,
At
Aadhaar.
least with regard to your identification, there is nothing.
Though after that, they ask for my bank statement, mobile number, and everything. I will provide these documents, my lord, physically being present in Jalandhar and virtually being present in Kolkata. My lord, the purpose is the same. My lord, they want to question me. If they want to question me, but for me being present physically, but arguing a matter before your lordship virtually or physically has the
But
same.
the investigating agency, if it is a witness, why the investigating agency
Let-
are not coming? And
Actually, it cannot be done because documents are to be confronted with, to be signed with. Whatever document he gives required to be verified, signed by him physically. Virtually, it cannot be. What I have
that's why your officer can come and investigate the matter here. Record the statement.
What I have submitted, allow him to appear through his authorized person. The authorized person will produce the documents, will participate in the investigation in Jalandhar. If the authorized person cannot answer any question, then the next course of investigation will come. Nobody can ask.
So that's why if and but that
But
should not
let him
be.
try because he says he's aged. Let him authorize a person who can appear in the investigation.
My lord,
Then
this court has previously, my lord, I didn't wanted to Mr. Is there, my lord, I didn't wanted to realize that this court has previously held that investigations or any other that they were accused. My lord, I am only asked for the purpose of evidence, my lord. This court has already held that or decided has decided that the questioning can be done in Calcutta. My lord, in case of Delhi, my lord, this is with regard to the coal, my lord, the
this
coal
is a
scam.
case where the summon was active. Here the petition itself has become infractuous today.
My lord, according
no
to me, my
cause of
lord,
action.
they asked me, my lord, after I filed, my lord, I have not received. Let them say that you are not required to be present. I am only seeking for only two things, my lord, today. That I am not saying that I will not participate in the investigation. I will not assist the investigation. I say that kindly do it through virtual. Let me get well. If such situation arises, they can come. My lord, the question, my lord, I am not saying that I will not participate. A person discharged on 12th. Today we are on 15th, 2 days ago.
There is no date for his appearance as on today.
But as on
It
date,
lapsed on 10.
but tomorrow they
There
will
is
come
no
up with
cause of
another. I'll have to again come up with another writ petition. But tomorrow notice will come. I'll again have to come up with another writ petition. I am not saying that, Amalat. Kindly take my bona fide. Amalat, I'm not saying I will not participate. I am not asking for a stay of the summons. I'm not asking for anything. I am asking that let me be present virtually or let them investigate in Kolkata. Not possible for me to go to Jalandhar.
Come.
Well, in Kolkata, it is not possible.
Why?
I am saying I have taken instructions. Well, this is a case. I was not intending to go into such details. But this is a case having a pan-India effect. This particular gentleman has a transaction over 17 crores in that process. But if my IO is to come to interrogate him in Kolkata, he is to carry all those documents, which are voluminous in nature. It's a pan-India document. So he cannot come with all those documents to confront him in Kolkata office. There's a practical difficulty. And as on date, this petition has no follow-up.
India basis.
He
My lord,
was released
my lord,
by way of
people
appearance
from
to
pan
appear.
India, my lord, investigating officers, my lord, cannot take the plea. My lord, kindly
The
give.
petitioner has filed the present application praying for a direction. Petitioner has filed praying for a direction. The ED authorities either to interrogate, either to examine the petitioner through virtual mode or at the Kolkata branch office. The counsel for the petitioner submit that on May 2026, the ED has issued the notice under section 50 within bracket 2 within bracket 3 of the PMLA Act, directing the petitioner to appear before the Enforcement Directorate on 2nd of June 2026 at 10 a.m. to give evidence in connection with the investigation and the proceeding under the PMLA. Counsel for the petitioner submit that the notice issued by the authority was received by the petitioner on 26th of May 2026 at 4:53 p.m. and immediately the petitioner has informed the ED authority that the petitioner has received the notice only on 2nd of June 2026 at 16:53 hours, and he could not, due to which he could not approve. It is the further carefulness. It is the further case of the petitioner that the petitioner is 76 years of age and suffering from various ailments and was admitted in the hospital from time to time, and as such is not in a position to appear before the authority in person for recording his evidence. Thus, recording his evidence. On when the another note on 10th of June 2026, the ED authorities again fixed the record, the examination of the petitioner, but the petitioner could not appear before the court before the authority as he was admitted in the hospital. Again, he made a representation to the authority for examination of the petitioner either through video conferencing or at the Kolkata zonal office. Police staff. If Learned Counsel for the petitioner submitted, the petitioner is ready and willing to cooperate with the investigating agency either through video conference or they will examine the petitioner at the Kolkata zonal office. Learned Counsel for the petitioner further brought to the notice of this court to the notice dated 26th of May 2026, wherein the authorities have directed the petitioner to submit the self-attested copy of the PAN card, Aadhaar card, passport, details of bank accounts, details of immovable properties, and details of mobile number. The submitter, petitioner is ready to submit all the documents to the authority through the email. Or if the petitioner will examine at Kolkata General Office, he will submit all the document, but is not in position to go to the Jalandhar due to his old age and suffering from various ailments. Learned Counsel for the ED has raised objection and submit that there is no cause of action in the present date application. He submit that first notice was issued on 26th of May 2026 with the direction to the petitioner to appear before the ED authority on 2nd of June 2026. Subsequently, the date was fixed on 10th of June 2026. That day has also been over, but the petitioner has not appeared before the authority, and as such, no order can be passed in the present date. He further submit that the ED authority submitted the investigation of the on instruction. He submit that the matter relating to several documents. And if this court will allow the authorities to examine the witness at the Kolkata zonal office, the AD authority has to bring the voluminous document to the Kolkata, which is not possible for the authority to bring all the document for one person at Kolkata, because the investigation is going on at Jalandhar. He further submit that if the petitioner is not able to appear in person at this stage, the petitioner can appear through the authorized representative with all the documents, and the representative should give all the answer to the questions, if any, raised by the authority at the time of evidence. Full stop. He further submit that if the authorized representative is present before the ED authority and is not able to give the answer to the authorities, then the petitioner has to appear before the ED authority in person for regarding his statement. Had the learned counsel for the respective parties peruse the materials on record. The petitioner has relied upon unreported judgment passed by the unreported order passed by this court in the case of Menka Gambhir versus Union of India and others in WPA 19748 of 2022, wherein the coordinate bench of this court has allowed the Directorate of Enforcement Directorate to question the petitioner at the Zonal Office at Kolkata. He prays for the similar order in the present case. At the learned counsel for the respective parties peruse the materials on the court. The Enforcement Directorate had issued the notice to the petitioner on 26th of May 2026 by directing the petitioner to appear before the Enforcement Directorate at Jalandhar on 2nd of May 2026, but the petitioner has received the said notice only on the 2nd May, and as such he could not appear before this court, but the petitioner has responded the said notice by sending the email. The authorities, after receipt of the email, has fixed the another date on 10th of June 2026, but the petitioner has not appeared on the ground that the petitioner was admitted in the hospital. The petitioner has discussed several medical documents to show that the petitioner is 76 years of age and suffering from various ailments and was admitted in the hospital from time to time. Considering the above, the petitioner is directed to give an authorization to his representative to appear before the Enforcement Directorate at Jalandhar along with all the documents as required by the authorities, and the ED Enforcement Director is directed to allow the representative of the petitioner to appear before the ED authority on behalf of the petitioner. In case the ED authorities find that the representative of the petitioner is not in a position to give proper answer, which the ED authorities required for the investigation, then the ED authorities shall give minimum 15 days time to the petitioner to appear before the ED authority at the Jalandhar.
One more thing, my lord. Till the time notices are issued, my lord, and my lord, no coercive step, my lord.
What coercive step?
Nothing has been
Nothing.
done yet.
Nothing.
By asking
This
that,
was-
you are inviting for coercive steps.
Don't do all the things.
By asking that, he is inviting deeply obliged.
Obliged.
Your Lordship, I direct them to take instruction in the show cause notice, what has been said, on the basis thereof that the removal of the name of the petition on the approved contractor list can be yours.
Yes, have you taken instruction?
I hand over the copy.
দিবি না মামলা ওপর দিবি
I got kindly please.
Okay.
Second page.
Yes.
E, my lord, E. National security and implications.
E.
E.
Second page, E.
Page 2, my lord. The first one is
I can get you one
covering
copy.
letter, my lord. And internal page 2, my lord.
Enter pen 2.
The lordship report.
Clause 3. There
Clause
is
3E, my lord.
3E.
Yes.
National security implications. Yes.
The military.
Yes. Yes.
The military engineer services provides strategic engineering support to the Indian Army, Navy, and Air Force. The department cannot place its trust in a contractor who will be compromised, particularly when executing work inside sensitive defense installations. Deploying substandard or unverified equipment in such zones possesses a direct security hazard to the nation. Now, your lordship will come to the guidelines which my learned friend had relied on the earlier date. Guidelines of for suspension, departments, demolitions, and removal of NES contractors.
Yes. Page.
Internal page 3, my lord.
No, page. Repeat it.
My lord, this was a loose document which my learned friend.
I've given, my lord. I'll give one again.
Yes.
My lord,
Yes. Removal and approval list.
Guidelines for suspension, departments, demolition, and removal of MES contract.
Yes.
My lord, internal page 3. Cancellation of enlistment. My lord has got it.
Page number?
My lord, it is internal page 3.
Internal
This
3,
guideline.
Yes, cancellation of enlistment.
My lord, point 2.
Yes.
Violates any conditions of the contract or fails to abide by the conditions of the enlistment. So, my lord, we have acted in terms of this guideline. We have this listed because we have violated the terms of the contract by producing fake vouchers of the material which he has supplied to the MES, my lord.
Yes. No, the question is that I totally appreciate with you. Kindly come to the national security implications, correct, which you are relied upon. Military engineer provide the strategic engineer support to the Indian Army, so and so, plus to contract whose integrity is compromised, particularly when the executing the work sensitive defense installation. Sensitive defense installation. That's why on the last occasion, this court has categorically asked you because as per the resolution taken by your authority, there is no allegation with regard to the material supplied by the petitioner is the degraded materials or not up to the mark of the material. The only question with regard to the bill raised by the petitioner, and the bill raised by the petitioner is that petitioner has not given the bill from the authorized agent, he has given the bill from the local agent. That is the question in the matter. So whether that is coming under the purview of the national security.
It comes, my lord.
How?
My respectful submission would be, my lord. Here the integrity of the contractor is in doubt, my lord. For such a sensitive place, my lord, today he has been caught for the false vouchers, my lord. Fabricated vouchers, my lord. Now we cannot wait for somebody who will commit a further crime and then we dismiss him.
So
because he has violated the terms of the contract. It is a very sensitive place where it requires special requirements for the contractor to work in such places, my lord. Now, since he has been caught with the false vouchers, my lord, now this cannot be got into, my lord, whether the material was bad, whether the quantity was not good. Because here, my lord, the requirement itself says that he has to produce the original vouchers and bills, my lord. He has taken a material from somebody else. He has given a vouchers and bills from somebody else. Now, since it has been caught at the time of making payment, my lord, so these contentions cannot come in right now, my lord. The integrity of the contractor itself is in doubt.
Where is the so-called notice?
Is at page 138. 138, my lord.
Kindly see scope, my lord, of show cause.
Yes.
Point 4.
Yes.
In view of the above, please show cause why your firm shall not be removed from the approved list of contractors of this HQ due to submission of fake vouchers as referred above in compliance with the enlistment letter. The act itself is bad, my lord.
Yes.
Now, it resultant cannot be weighted, my lord. The act itself is bad.
Have you initiated a criminal case?
My lord, there was a provision in the contract itself. So we have applied the provision of the contract.
Yes.
We have delisted so that he does not have a further opportunity to produce fake documents in the
Okay.
such premises, my lord.
Okay. Yes.
My lord, my London has not given an answer to the page 142. That what has been given by them. My lord, they said they got the materials, they have recorded in the MB, they have said I got the bill from the local markets. My integrity has been recommended. At page 40, the authority has said about my integrity. Everything has said. What now London has taken otherwise. Apart from this, my lord, here I have been removed. I just read it, Megan. The allegation in respect of CA, which was proved by one man inquiry in a separate event. The same has also been accepted by the contractor. It is a fact that contractor, whatever he had brought the material and incorporated into the work as per CA specification. After full satisfaction, the engineering charge, same was incorporated site and accordingly measured in MB. The subject work was an emergent nature work, importance of PMS to March being existing 17 corps. A number of regiment along with vital important installations are in PMs. To continue the enhanced security, continuous power supply is warranted even in breakdown from the state electricity board, for which DC sets are to be run instantly and continuously. The state contractor had attended all the complaint instantly and even on night or during storm rain reasons made the equivalent in serviceable condition by hook and crook. To run the equipment in urgent basis, obviously either he had to procure the materials from local markets or he had used to the materials which are held with him, but without genuine purchase voucher. Perhaps procuring the materials from the dealer may delay to the user and may result dark nets of the particulars are area for a long time. However, whatever he had done, the contractor is fault and the same is punishable offense. Next, the contractor United Builders is a hard worker, technically and financially sound, intend to complete the work in before time, always ready to execute of the any kind of difficult work and not a litigated minded. The contractor has admitted the allegation given his assurance for not repeating of such mistake by later such and such. Keeping in view, the undersigned recommended for sustained business dealing for a repeated period, not for lifetime. This is my lord. My lord. Moreover, my lord, I just there's a judicial pronouncement, my lord, also. Can you see the Supreme Court says, my lord? Paragraph 26, 20. ওকে দেওয়া হবে আছে হবে তুই ওটা তোর রিপোর্ট আমাকে দিলি না কিন্তু paragraph 26 in Kulja I also got it.
Yes.
In Kulja industry, this court has observed that a debarment is never permanent and the period of debarment would invariably depend upon the nature of the offence committed by the erring contractor. In the said decision, this court emphasized on prescribing guideline by determining the period for which the blacklisting should be effective. It is observed and held by this court while determining the period for which the blacklisting should be effective for the sake of objectivity and the transparency, it is required to formulate board guidelines to be followed. It is further observed that different periods of debarment depending upon the gravity of offence, violation, breaches may be prescribed by such guideline. Paragraph 28. Duration of blacklisting cannot be solely part of offence. Seriousness of the lapse and the incident and of the gravity of the omission on the part of the contractor which led to the incident should be the relevant consideration. In a given case, it may happen that commission or omission is very grave, and because of the serious lapse and negligence, a major incident would have taken place. In such a case, it may be the contractor first offense. In such a case, the petitioner's period duration of blacklisting can be more than 3 years. However, the same guidelines are not under
Yes.
child. So
My lord, my respectful submission is this is with regard to blacklisting a department. We have cut his name as an enlisted contractor.
Remove, this is
That
same
will
thing.
Not have any repercussion for other places to work, my lord.
Okay. The petitioner has filed the present writ application challenging the impugn order dated 17th of November 2025 issued by the executive engineer within bracket SG within bracket QS and C, joint director within bracket contacts of the chief engineer. By remove the name of the petitioner from the approved list of the contractor of the headquarter with immediate effect. The petitioner is the approved contractor under the military engineering services and was awarded with all the works as described in schedule. Where is the schedule? On the last occasion I also mentioned.
Yes,
Where
yes,
is the
I
schedule?
showed. Page 7, the page 7, page
Huh?
79.
Page
79.
schedule as appearing in page 79 of the present application. On 30th May 2025, the chief engineer has issued the so-called notice to the petitioner on the allegation that the petitioner has submitted fake bills with respect of fake 4 bills. Fake four bills of Mrs. Pal Automobile and Mrs. Ajay Battery. And accordingly, the petition is directed to show cause why the petition name shall not be removed from the approved list of the contractor. The petitioner has submitted a reply on 20th May 2025, informing that the material which have been supplied by the petitioner is of the approved make, and even till date no complaints have been received against the petitioner. The material supplied by the petitioner is genuine and the approved genuine, full stop. But the staff of the petitioner has purchased the said material from the local shop and unable to deliver the genuine bill and the said act of the petitioner and the petitioner was not aware that the staff of the petitioner has submitted the bills from the local market. On receipt of the so-called reply submitted by the petitioner, a proceeding, the authorities have recorded the proceeding by recommending for suspension of the business of the petitioner for a definite period, not for lifetime. Subsequent to the resolution taken by the authority, the impugn order is passed. Learned counsel appearing for the petitioner submit that that in the resolution, comma, the authorities have admitted that the contractor had attending all the complaints instantly, and even on night or during storm/rainy season, made the equipment in serviceable condition by hook and crook. Full stop. To run the equipment in urgent basis, obviously either he had to purchase the materials from local market, or he had used the material which were held with him, but without genuine purchase voucher. Without genuine purchase. It is also recorded that perhaps procuring the materials from the dealer may delay to the users and may result darkness of the particular area for a long time, due to which the contractor due to which the petitioner has procured the materials from the local market. Full stop. In the recommendation, it is also held that the petitioner is a hard worker, technically and financially sound, intended to complete the work in before time, always ready for execution of any kind of difficult work, and not too litigated mind. Full stop. In spite of recording the set of full stop. Land Council for the petition submits that there is no allegation that the materials which has been supplied by the petitioner is not genuine one or not up to the mark. Only the allegation that the petitioner has produced the material, has submitted the vouchers from the local market instead of
$90. Matha.
instead of from the authorized agent in terms of the special condition of conduct. That counsel for the petitioner submit that only if the counsel for the petitioner submitted the only allegation with regard to producing of the voucher from the local market and not from the authorization cannot, and the respondent authorities cannot remove the name of the petitioner from the approved list of the contractor. The petitioner, in support of his submission, has relied upon the judgment in the case of State of Odisha and others versus Panda Interproject Limited, reported in 2022, Volume 4, SCC 393, and submits that department the department can never be a permanent, and the period of department would be invariably depend upon the nature of the offense committed by the erring contractor. By referring the said judgment, the petition submitted in the present case, the only allegation that three false bills has been submitted by the petitioner from the local market instead of from the authorized agent, but the material supplied by the petitioner is up to the mark. There is no allegation that the material supplied by the petitioner is degraded. And as such, but the respondent authorities have removed the list of the name of the petitioner, from the approved list permanently, which is not sustainable under. Per contra, an advocate appearing for the respondent authorities submit that the petitioner has violated the special conditions of the contract. He further submit that as per the contract, the petitioner, the contractor has to produce voucher oblique invoices from the manufacturers or their authorized agent for full quantity of the materials. But in the present case, the petitioner has submitted a fake voucher from the local market. And thus the petitioner has violated the terms and conditions of the contract. The counsel for the respondent has further relied upon. What is this? What you have produced today? Relied upon.
Ricky issue.
Huh?
No, these are national.
What you have relied? What is this? What is this today you have produced? What is this? Relied upon the instruction relied by the respondent authorities. Wherein? This document, where from you got this document? Draft statement of fact of what? What is this? This is a clause 3, clause 4. Where from you got this?
document
Has submitted a document relied upon the instructions from the submitted by the authorities, wherein it is mentioned that the military engineering services within bracket MES provides strategic engineering support to the Indian Army, Navy and Air Force. Full stop. The department cannot place its trust in a contractor whose integrity is compromised, particularly when executing the work inside the sensitive defense installations. Deploying substandard or unverified equipment in such zones poses a direct security hazard to the nation. By referring to said clause, the petitioner and the respondent authorities have further relied upon the guidelines for suspension, debarment and demotion and removal of the MES contractor, wherein clause D, II provides that the cancellation of investment can be done for violations of any conditions of the contract, and the contractor fails to abide by the conditions of enlistment. By relying upon the said document, the petitioner submitted the petitioner by submitting the fake document has violated the terms and conditions of the contract, and as such the authorities have rightly removed the name of the contractor from the approved list of the contractor. Had the learned counsel for the respective parties peruse the materials on record. The respondent authorities have issued the so-called notice to the petitioner on the ground that the petitioner has submitted the bill of Messrs. Pal Automobile and Messrs. Battery bill and Messrs. Battery dated 15th April 2023, 5th of June 2023, 5th August 2023, and 10th of August 2023, which are fake. The petitioner on receipt of which are fake, full stop. On receipt of the so-called notice, the petitioner has submitted his reply. In the reply, the petitioner has categorically stated that the employees of the petitioner purchased the materials from the local market and unable to deliver the genuine bill and have produced the bill from the local market, not from the authorized agent. It is not the case of the authorities that the bill which has been submitted by the petitioner has not been issued by Messrs. Pal Automobile or Messrs. Ajay Battery. It is the specific case of the respondents that the petitioner, instead of submitting the bill from the authorized agent or manufacturer, has submitted the bill of the from the local market. Thus, it cannot be said that the petitioner has submitted the fake bill. Only the petitioner has not submitted the bill from the authorized agent or manufacturer and had submitted the bill from the local market. On receipt of the so-called notice, the authorities have taken a resolution which reads as follows. Page 42. As follows. In the resolution, the authorities have admitted that the petitioner is working as a contractor under the respondent authority for the several years. And the petitioner is attending all the complaint instantly and even on the night or during the storm or rainy season, and made the equipment in serviceable condition. It is also recorded that the petitioner might have been borrowed the material supplied by the petitioner either from the local market or from his stock. It is not in the resolution. It is not the case made out by the respondent that the bill submitted by the petitioner with regard to the PAL automobile and Ajay battery are fake one. Only in the so-called notice, the authorities have used the word fake, but it is not the case that the said bill was not issued by the PAL automobile or Ajay battery. Full stop. The terms and conditions, special terms and conditions of the contract, clause 17.7 reads as follows. Page 90. 17.7. The only allegation, as per the said clause, the petitioner has to submit the voucher / invoices from the manufacturer or the authorized agent. But the petitioner has not submitted the same. Thus, if the materials which has been supplied to the petitioner is a genuine one, and there is no allegation that the material which has been supplied to the petitioner is degraded or not from the branded company, only with regard to the bill submitted by the petitioner from the local market, the authorities cannot pass the bill raised by the petitioner, but the authority cannot take severe action by removing the name of the petitioner from the approved list of the contractor. Consider full stop. The terms and conditions for cancellation of the enlistment provides that violates any conditions of the contract or fails to abide the conditions in the enlistment. If the petitioner has not produced the bill from the manufacturer or the authorized agent, the authority cannot pass the bill of the petitioner, but they cannot say that the petitioner has submitted a fake bill. Considering the above, this court finds that by passing the impugn order by removing the name of the petitioner from the approved list of the contractor is severe one, which is the severe consequences. Though the allegation is not so severe, only the allegation that the petitioner has submitted that the bill from the local market. Considering the above, the impugn order is set aside, writ petition is allowed. Next.
May it please your lordship. That pursuant to your lordship's direction, we have affirmed an affidavit.
Yes. What is the disputed clause? What is the
Someone send
disputed
me a
clause?
copy. Lord, may I make a very humble submission,
Yes,
Lord, subject
yes.
to my Lord's pleasure. Lord, from January, we are waiting for the flats to be handed over to us. They have handed over the common areas. Now they are insisting that without registered deed, the flats cannot be handed over. Lord, in my humble submission, this is not absolutely wrong. This
No,
is
that's
absolutely wrong.
That I have taken care of it. Well,
Now, Lord-
what is the disputed in the this terms and
Lord, your Lordship will
conditions?
see. Lord, Lordship kindly takes up my affidavit, Lord.
Yes. This is your draft. This is your draft, Mr. Samantha?
Yes, Lord. The second one, P16 is our draft, and P15 is their draft, Lord. Their draft does not take care of anything.
P16. Yes.
Which is my approved draft, and page 14 of their supplementary affidavit, which is their draft.
That's why I'm asking what
I have annexed in both of them. I have annexed in one single. Lord,
P16 is their draft. Your
our
draft.
draft. Lord.
Yes.
Our corrected draft, and theirs is P15. Lord.
Yes.
Lordship will see. We have marked it, Lord, so that your Lordship can appreciate.
Yes.
These have not been taken care of, Lord.
This red pen.
Yes, Lord.
Red ink.
Yes, Lord.
And what about the yellow?
And their sale deed, Lord.
What is the yellow marks?
Yellow mark is not that. It has to be, once it is to be corrected, that part cancelled out, Lord. উল্টো করে দিয়েছে আচ্ছা ছেড়ে দাও ঠিক আছে
Yes. What is your difficulty?
I'll come to page number 6 of my supplementary, which is the approved draft, subject to the proposed corrections being proposed by the PDC.
6 is 6.
Page number 6.
What is the 5? It starts from 5.
The starts from 5, but the material portion starts from 6. The
Ah.
page is 5. But the first correction which has been shown by the petitioner at page number 15 has been corrected. Please.
Just a minute. Now kindly come to the page 14. It starts from 14. 14 and you are 5.
5, yes.
Correct.
Yes.
The covered open car parking space. So they wanted the cover or open. It is cover or open.
Both types.
But that has been corrected by us.
No, you are given only open car parking. Come to the page 5.
Yes, page 5.
Yes. You are page 5. They are 14. You are page 5.
Yes, your lordship.
Correct. Open car parking space. So here they have covered. Where is the covered?
Open car parking space.
You have given open, but they have also recorded the covered.
It was open car parking space, and that has been recorded.
There's no covered car parking.
That change of
Covered and open both. Covered and open both.
Yes, covered and open both.
Yes.
So whose place has been given the open, it will be given open. It
yes.
will cover. It will be covered.
No, unnecessarily they are wasting
Correct.
the time of the court, my lord.
Huh?
I believe, my lord, instead of looking into that, my lord, your lordship, we can sit together. But in the meantime, my lord, let the flats be handed over. Because the common space has been handed over on 19th May, 19th April, from 19th March, my lord. From 19th March, common space has been handed over and we are waiting.
Yes. So you've taken care of it, this correction, this 17?
Well, I'll take care of the correction. It will be covered and open.
That is correct. Now come to the page 17.
Page 7.
Page 17 of their affidavit. So why you're not why you're not giving the position?
Now, let me show the only difficulty your lordship is with regard to the third schedule. If your lordship comes to the third schedule, I'll clarify the issue.
Where is the third schedule? Page number?
Page number 25 of their supplementary.
25.
Yes, your lordship.
Yes. Third schedule referred above.
The issue is your lordship. Where is the last 5 lines?
25 of their affidavit.
25.
Of their affidavit.
Of their supplementary.
Yes.
Now the underground GI pipeline which was connected to the pump would draw water from the semi-underground reservoir and deliver to overhead reservoir to GI pipe. Designate and from where water would be finally distributed to flat apartment to GI pipe network. The water will be supplied to the underground reservoir from deep well, from the BMC water supply network as well as the pump water from the deep well within premises. Now we are objecting to the BMC water supply because this BMC water supply was taken as a temporary measure for the purpose of construction. This BMC water supply connection was never provided in the brochure as well as it was never in the GTC. The petitioners are approaching the project by look at the brochure as well as the GTC. So the GTC and the brochure, the housing board cannot go beyond that. Now, what has happened during the execution of the agreement for common areas and facilities? Now, during inspection, it was found that this water connection was also there. However, this water connection was taken for a temporary measure in order to afford the housing board for the purpose of construction. Now, this temporary water connection would not be able to provide water supply to the entire plant. Well, this has happened with some other projects also, but if the same problem has occurred, now the housing board is facing problem because they could not supply the water because that was not there in the GTC as well as not in the brochure. So this is the what I feel from the conjoint reading of both their proposition and my client's proposition. The only issue is with water supply. Other aspects can be settled out. Let him point out. I'll settle the issue. But this BMC water supply cannot be your lordship.
Because BMC water supply is part of the thing. They are giving that supply because they have two ways of supply. One is BMC supply and one is from underground supply. Both are there. That is there. And fourth schedule, my lord, they have not included at all. Fourth schedule, lordship kindly comes to.
No, with regard to this, this water in the GTC, it is mentioned.
The, GTC, they have deviated from the GTC in many ways. That they are holding GTC to be sacrosanct. But fact is, not after that, they have changed or altered many things. And that has not been considered by them. They have given a deed, a draft deed, Lord, which is actually really a what you call a regular type of deed without details. But that is not the case here. Here, my lord, in fact, the fourth schedule, if your lordship sees.
No, if in the GTC and water, if the water supply is not there at the time of the GTC, how you can be entitled for the BMC water supply?
They are giving it. They have given, BMC has given us the this thing, my lord. The sanction and everything they have given.
That sanction
they are not being considered.
That sanction is the permanent or the temporary sanction?
Well, that is a temporary sanction as I have been.
How can it?
How? Where is the sanction order? If it is
they have given us possession.
What is the sanction order? If it is a permanent, then if you provide the water, they will, with regard to the in future, they will bear the cost, whatever it may be. What is the
Well,
what is the problem?
We don't have any issue with regard to the supply of water, but
Ah.
we cannot deviate from what is there in the brochure as well as in the general terms and conditions. So the brochure says that it is from GI pipeline and deep tube. There was no provision for BMC water connection.
Okay, no,
If the BMC water connection,
if the BMC is there already,
yes, you
so instead of disconnection, let it be continue. Why you wanted to discontinue?
then your lordship, it can be included subject to that all the future.
Yes, they will be naturally.
Housing board will nowhere be liable for.
As it is, my lord, we have to bear. We are already bearing electricity, etc. We are bearing.
Once you handed over the possession, it is at
And the common space they have handed over already. They are from 19th, Lord, 19th March. The common space has been handed over. We are making payment. We are making electricity payment.
How the housing would will be in difficulty after the execution of the deed?
Now the contention of the business.
After the execution, I think they have made a association.
Association is there.
Association will
Registered
carry out this
association.
thing.
Well, let me only consider that when there is no provision in the brochure.
I appreciate but something here and there. Once you got already a municipal water connection, you already got it, and you are getting it. The municipal is not that's if it is not a temporary, and there is no notice of the municipal for removal. So what? Let it be continue, and the person will. It is a question of water.
Yes, your lordship.
So.
My lord, another one more thing, my lord.
So,
the fourth schedule, my lord, lordship kindly looks at fourth schedule.
That may be recorded.
Yes.
So let them did not disconnect, and in future, whatever the payment and whatever this, the association of the flat
That is
owners will
already
be
there.
responsible for
But
that.
may I make a humble submission, Lord, subject to my lord's pleasure. Lordship kindly comes to fourth schedule.
Yes, I am there only.
Fourth schedule, my lord, is not included.
Yes, fourth
How?
schedule.
Why we have made payment in this way?
Payment schedule.
Well, as far as this port schedule is concerned, I have also advised my client that port schedule should have been included. But their instruction is in all the deeds with the housing board executes in all the projects, they do not have the provision for the port schedule. In the deed of conveyance, your lordship. Now, if your lordship feels that this should be included,
that will be clear.
Yes.
In future, if any person
Yes.
yes, this will be clear.
Because how we have paid the money.
After 10 years, the bank will say, no, it is all electronic that has gone. I cannot.
My lord, upon reading their proposed correction, I have this part as far as the port schedule is concerned. I have also advised my client that this should have been there.
You do one thing, you correct all these things, and with regard to the third schedule, you
Port schedule will be included. BMC connection will be included.
And they will write the BMC water supply after registration and taking possession, they will be liable for payment of
That is already
all
there.
the charges. That is already
Lord,
there.
may I make a humble submission, Lord? Lordship does this, Lord, because they have given us the common this thing. Let them hand over the flats immediately. Make these corrections later on, my lord, and Lordship keeps it pending so that the matter can be disposed of one time. But let them give the flats, my lord, because we are unable to use it for so long, 1.5 years.
Why you are not giving the flat?
Well, that your
And they have said.
Well, that your lordship, I won't be able to assist your lordship because the specific instruction from my client is that we cannot deviate from the GTC.
This is wrong.
The GTC categorically says that until and unless the deed is executed, flats cannot be given for this. Well, if we
Where is the GTC?
My lord, I'll show your lordship one thing.
Page 64.
My lord, in their affidavit, they have said it is stated that the West Bengal Housing Board, in their affidavit, my lord, paragraph 8, page 4.
Paragraph 8 of their affidavit.
Of their affidavit, my lord. Not the supplementary, my lord. I'm sorry. Not the supplementary. The report by way of an affidavit. It will be a thin document.
Yes.
Paragraph 8. It is stated that the West Bengal Housing Board, in compliance of its procedures, have already started the process of handover of the flats to its respective allottees. Steps have been taken on the part of the West Bengal Housing Board for handing over the possession of the respective flats to its allottees. When is the date, my lord, of this affidavit? It is not 20th April. Till now, they have not handed over. Let them hand over first, my lord, and the registration can be done subsequently. There is no problem. We shall abide by every this thing, Lord, but at least the flat should be handed over. Why cannot we use the flats? They will stop, my lord, after 2 months, they will stop the security arrangement. The flats will be left in the lurch without any security. They are linking up the GTC, saying that unless the flats are registered, we cannot hand over. That is not the correct procedure, my lord. That is never done. Lordship will pass an order, let them give it. Appoint a special officer and we'll get the flats handed over, my lord, at our cost. And then, my lord, defile him.
What is your
Lordship, I'll take your lordship to page number 62
Read the work,
64 of the PPT.
As if GTC is the sacrosanct thing, my lord. GTC cannot be sacrosanct.
My lord, GTC is sacrosanct as far the housing board is concerned. Your lordship can modify the
Yes,
GTC, but-
lordship will modify it, my lord.
That cannot be at the instance of petitioner, lordship.
That's why that without any
Lordship-
controversy,
Lordship,
without any.
Page
Yes,
62 7.5.
yes, I am there
That
on.
subject to the above, the possession of the dwelling units and the car parking spaces shall be handed over by the board to each allottee after payment of the final price of such unit and after execution and registration of the consent deed of transfer.
We have paid it 1.5 years back.
Transfer executed and registered within 2 months from the date of issue of execution notice.
Yes,
Allottee
sir.
will be liable for the guarding and charges. So
The execution notice was sent sometimes in the month of April.
then
So thereafter, this issue cropped up. The
Correct.
special officer was appointed to settle the terms of the deed. Now your lordship will come to page number 64 once.
Lord,
There is a
I am
clause-
beseeching your lordship only one thing, lord.
There is
What is the happiness in theirs for getting it delayed, my lord, giving the possession?
Madam, there is no happiness or sadness. The West Bengal Housing Board being a statutory body acting within a particular framework, it cannot go beyond the judiciary.
correct. So the authority has to act expeditiously.
Yes,
Why you are
madam.
doing this?
Your lordship proposed that we should submit the deeds today. The issues have been sorted out. Now
So I am directing whatever they did, they have submitted that let it be finalized and registered as early as possible and
So
to
the-
hand over the possession.
Flats handover
Well,
first, my lord.
there are two issues: covered parking space and DMC water supply. That will make correction and will produce to your lordship the final deed.
My lord, I tell your lordship, my lord, kindly directs them to grant possession, my lord. Special officer be appointed, let them give the flats, hand over the
How
flats
many
first.
flats?
My lord, there are how many flats? 41.
Now your
And
lordship-
they have already handed over the.
There are
You do one thing. When you will incorporate all these things and when you will confront day after tomorrow,
yes, ma'am, within 3 days.
within 3 days.
3 days.
They cannot do
If
it.
within 3 days you come with that approval
Yes, your
and
lordship.
serve the copy to my 2 years learned friend,
Your lordship.
and they will satisfy, they will sign this, and I will pass an order to immediately grant the hand over the possession and to register within fortnight.
Now, your lordship, there are two other aspects which are also required to be considered, which has been proposed by them and against the GTs. My lord, clause E of their deed.
My lord, instead of wasting your lordship's time, my lord, I'll tell you, lordship, the best way out. Lordship will appoint a special officer,
Because
give
lordship,
the flats,
again
lord,
come up for your-
and then, my lord, all this can be sorted out. I'll sit with my learned friend, lord. I personally will sit with my learned friend. But lordship will pass that order. Fortnight, they will give the possession.
So I appointed the special officer, but it
He
could
did not come, lord. He was, because he was elevated, that problem cropped up.
Spending.
My lord, lordship will do this, my lord. Kindly, any other
You
special
do one
officer.
thing, you both give the name of the joint special officer. I will herein now I direct the special officer along with both the advocate on record will sit together, finalize and hand over the document and
My lord, that will do, my lord, but flats, my lord, first
same
hand over.
thing. Once it has been finalized, then party has to sign.
My lord,
Other
my lord,
tomorrow
one thing,
then
my
there
lord,
will be
subject to my lord's pleasure.
There will be
My lord, from 1.5 years we are waiting. We have
Correct,
made the
correct.
full payment. My lord, the common space has been already given to us. Now, my lord, what difficulty they will have in handing over the flats? Kindly grants that order, my lord.
Only with regard to the condition.
Yes, ma'am.
Only with regard to the condition.
Yes, your lordship.
No, otherwise nothing.
Otherwise, they have proposed two changes.
Proposed to changes, you can do that.
That is not permissible, your lordship.
Which one?
This page number 11 of their supplementary evidence.
They will take on and on and on, waste your lordship's time, my lord. Lordship will give us this order, my lord, kindly, I beseech your lordship.
Page number 11 is your affidavit, your document.
Yes, your lordship, my affidavit. I'm stand corrected. The board shall not pay the maintenance charges for any vacant apartment in the said project after the common areas and facilities pertaining to the said project have been handed over to the apartment owners association. So they have issued an objection with regard to this clause. So whether they have this objection till now or because this is as per.
Yes, with regard to the maintenance, the board shall not pay the maintenance charge, etc. to the vacant. What is page 22?
My lord, since we have not been handed over, my lord, we are not in a position.
After handing over.
After handing over, my lord, the moment they hand over, already we have started paying electricity, etc.
That continue. So why it is so? Sir, why it is?
Board shall not pay maintenance charge.
Once you will take the registration after the possession.
There are 41 flats where the petitioners. The rest are not with us because they have not yet been sold. That part is will be difficult for us.
No, pay the access for vacant apartment in the said project after the common.
Which are not with us, my lord, because the moment we are given possession, okay.
Vacant possession.
Yes, because they have not been sold out.
See, can you read that?
But the board
shall not pay the maintenance charge, etc. for any vacant apartment in the said project after the common area and the facilities amenities pertaining to the said project. They are already handed over the apartment owner.
Yes.
So
not fully handed over. 41 with us.
But 41 flats are there.
Correct.
There may 45.
54.
Flats.
No. 54
flats. So there are vacant flats. An association has been formed.
Correct.
Of that entire 54 flats.
No, because they have not. They have not sold out.
My lord, if the flat is not sold, how can the owner of that flat come into that association? Now
They have not come.
How many owners are there now?
41.
Only 41. And the flat is total 54.
54.
So what will happen to the other?
They have not sold because the second time they are selling.
My lord, if there are no occupiers, there is no owners of that plot, so there will be no maintenance charges. So maintenance charges will be only with regard.
Why on us when they are vacant?
So there is no cost of maintenance of that flat. Once.
So that is to be clarified. So there is to be clarified.
They have not sold it.
The
13 flats.
The 13 flats which are lying vacant with regard to the access the other area till that has not been sold out. These purchasers will not be liable to pay anything.
That's all.
No. They will not be liable to pay anything about that flat anyways because there are 40.
So then you are telling that the board shall not be pay maintenance. If the board will not pay, so who will pay? If suppose 10 years you have not sold it, and the authority have issued the notice for demolition for not payment of the tax and all these things.
Housing board is the developer. After suppose there are 54 flats, 41 have been sold and 13 have
13 lying vacant.
Yes, lying vacant. Now an association has been formed. The association has been handed over the charge of the entire building.
No, it is only the common space.
How it can be unless and until that has not been sold? How it has been given to the person? So tomorrow they will occupy the 12 flats.
Well, housing. If that flat is sold at the time of selling of this flat, housing board will execute a deed of.
That's correct, sir. That's correct. Suppose these 54 flats are there, along with the open space and all these things. The total area has to be maintained by the association. If the deed is registered.
We have already started.
Deed is registered only 41, suppose. And 54 is lying vacant.
13.
13 is lying vacant. 13 is lying vacant. And that is not to be sold by these petitioners. That has to be sold by the board only. Board is the developer. So if developer is not selling that, so how they will maintain that unless and until it has been sold and the person will come, he will come as a member of the association, then the charges will be taken 5%.
That is why, my lord, I am beseeching your lordship. Lordship will direct within a fortnight, let them give the possession. And then, my lord, the rest can be sorted out.
If there is no owner in respect of a
So how this owner, this association will pay the total building with regard to that owner, with that portion?
And who will take charge of that? We don't have the law key.
So tomorrow they will claim, yes, we are paying the total charges. So we may be we may be allotted that flat. So what will happen to the board?
Because of these reasons, my lord, I am beseeching your lordship to pass that order. That within a fortnight,
What will happen? How the flat which has not been sold, how the association will give the amount to the authority and the other things?
But once that flats will be sold, the
it is sold.
That's why you have to clarify.
1.5 years it has
You
not
have
been
to
sold.
notify the board shall not pay maintenance charges, etc. for the flat
Vacant.
allotted to the petitioners purchasers along with the open space and the car space, but the flat which has not been sold and the other spaces the board has to pay. That is the problem. I understand your difficulty, sir. Now I got hold of it. Call your own. Who is the senior manager? Call him. You are not selling and you are putting the burden to the purchasers.
We have already started making payment of electricity, etc. Everything.
If the 54, there is no 54 occupier, they are not the member of the association, how the association can pay? Where from they will charge? From their pocket.
It would have been easier if he had agreed to that, my lord, that the flats 41 be given just now and the rest can be sold.
A maintenance charge will be regard to the common areas and facilities. So if that 13 flats are not being sold, and if the proposed 13 flat owners are not using the common areas and facilities, why? And the housing board is not staying there. Housing board will not stay there. So there will be no use.
That's why you are not, you are the developer.
Yes, your lordship.
As per the development agreement, you have to develop, you construct the 54 flats along with the car parking and all facilities, and you will execute the deed. You will execute the deed. After the execution of deed, all the payment is to be made by the purchaser, who is the flat owner. Now, with regard to the 13 flats, if there is no owner, how these petitioners only on the basis they are the association, they are the member of the association is liable to pay
for the entire.
For the entire. How they will get from their own pocket? They are not using that.
Lordship will pass that order, my lord. Within a fortnight, let them give the possession and let the deed be sorted out after that.
Yes. No, you. Otherwise,
but the proposed corrections which they have sought and your lordship has.
No, E.
Well, as far as E, I have to take instruction. But as far as the BMC pipeline and the covered carriage is done, within 3 days, my lord, I undertake that corrected deed will be before your lordship, and I'll serve that.
Inclusion of the fourth schedule. My lord,
fourth schedule is
my lord, unnecessarily, my lord, I tell your lordship, my lord, easiest way would be to give the possession first and then the
facts of the petitioner in the present date application that though the open area has been handed over by the developer, by the corporation,
by the West Bengal Housing Board,
by the West Bengal Housing Board to the petitioners, but in spite of the housing board is not handing over the possession of their respective flats of the petitioners on the ground. Petitioner fully Learned counsel appearing for the board submit that as per the GTC clause 7.5, the possession can only be delivered to the purchaser only after the execution of the conveyance deed. If further submitted deed, the conveyance deed has not been finalized, there is some dispute with regard to the terms and conditions of the same. Thus, it is not possible for the board to view the possession. There is another difficulty in the draft deed. In the draft deed submitted by the board, that in schedule 3, there is mentioning of the water supply to be underground from the BMC water supply network, as well as the pumped water from the installed deep tube well within the premises. The learned counsel appearing for the board submits that the board being the developer has obtained the water supply from the BMC for the temporary basis for the construction of the project, and as such the same cannot be allowed to use by the purchaser subsequently. This court find full stop. The learned Mr. Samanta, learned advocate appearing for the petitioner, submit that the board has not included the fourth schedule with regard to the details of the payment made by the petitioner for purchase of the apartment. At the learned counsel for the parties, this court find that the board has already obtained the water supply network from the BMC, and once that has been
Lord, page 119 is the occupancy certificate, Lord. Page 119.
क्या बोला? Obtain water supply and as क्या बोला? From the BMC, and as such it would not be proper for disconnection of the said water supply, comma, the water supply shall be continued, but there will be a condition in the agreement that after the transfer registration, after taking possession of the flat by the respective flat owners, comma, the flat owners shall pay the charges of the water supply made by the BMC, and the board will not be responsible for payment and maintenance of the pipe connection provided by the क्या बोला? Payment of water charges and maintenance of the said connection. As regard the schedule 4, the learned counsel appearing for the board submit that the board will incorporate the fourth schedule with regard to the description of the payment made by the purchasers, flat owners. Now the only question that whether before registration of the deed, comma, the flat can be handed over to the flat owners.
Lord, grant of occupancy was 3/9/2024 and payment was made in
flat owners. The further dispute arise that the said project consists of 54 flats. Out of 54, only 41 flats have been sold or purchased by the sold to the petitioners / purchased by the petitioners. 13 flats are lying vacant. In the draft agreement, at clause 8E, we didn't make it a small e. It is mentioned that the board shall not pay the maintenance charges, etc., for any vacant apartment in the said project after the common areas and the facilities of the communities pertaining to the said project, as they are already handed over to the apartment owners association.
Which is in consonance of 8.4 of GT. Which is this clause is in consonance with 8.4 of
Learned counsel for the petition submit that the said clause have been incorporated in consonance with clause 8.4 of the GTC. Consider the submission made by the counsel for the parties and the main clause of the 8.4 of the GTC. Admittedly, the project consisting of 54 flats, only 41 flats have been sold.
And association formed, Milord. And association formed there.
And these 41 purchasers have already formed their association. But the remaining 30 flats are lying vacant. And this unless and until the said 13 flats has not been sold, it is not possible for the association to include the said persons as the members of the association. The association has to pay all the charges with regard to the maintenance and other charges of the said flats. Unless and until the 13 flats have been sold and occupied by the subsequent purchaser, comma, this court failed to appreciate that how this purchaser shall pay all the dues, all the maintenance charges with regard to the vacant flats. Accordingly, the accordingly, the clause 8E is to be modified to the effect that the purchasers who have already occupied their flats shall
Not occupied, because we have not been handed over.
now I am recording, so occupied, with respect to the said flats, the board shall not pay the maintenance charges or the maintenance charges, but with regard to the vacant apartment, the board shall continue to pay till the allotment is made, and once the allotment is made to the purchasers, the purchasers shall pay the maintenance charges. Charges from
Possession,
the
not
date, from the,
allotment done,
from the date,
possession.
from the date of taking the possession.
Possession.
Full stop. ঠিক আছে তো? That is the, otherwise how the burden can be given?
Where your lordship was dictated that the fourth schedule, the learned, when the may that be recorded, the court feels that the fourth schedule be.
Huh?
But that paragraph where your lordship was dictated that fourth schedule, the learned counsel for the board, if your lordship just indicate that the court feels that because they have.
Court feels okay. ऊपर में फोर्थ शेड्यूल है ना, लैंड काउंसिल फॉर द रेस्पोंडेंट रेडी टू इनकॉर्पोरेट ना, वो जगह बोलो.
The lordship will pass the order, my lord, for grant of.
I will. No, ऊपर इससे पहले फोर्थ शेड्यूल. That there is no practice for including the fourth schedule. But this court finds that for future clarity, clarity with regard to the making payment by the purchaser with respect of their flats, the fourth schedule should be included. By giving the details of the payment made by the purchasers of their respective flats. Okay. Considering the above, this court direct the board to rectify to prepare the sale deed accordingly in terms of the above directions within a period of 2 weeks from date, and to supply the copy to the land council for the petitioner, to the petitioners, full stop. In the meantime, pending registration of though as per clause 7.5 of the GTC, possession of the dwelling unit and the car parking space of the set units is to be given only after registration of the sale deed. But this court find that the flats have been, the construction has been completed.
3/9/2024, my lord. Page 119.
September 2024.
Occupancy certificate given.
2024, and occupancy certificate has also been
And full
given,
payment made in.
and the petitioners have already made the full payment with respect of their purchased flat. Thus, the respondent, and thus the board is directed to immediately hand over the possession of their respective purchase plots to the petitioner within 2 weeks from date. Full stop. Let the matter it is made clear that giving possession of the purchasers with respect of their fraud is subject to the result of this writ application.
My lord.
Writ application. Let the matter appear on
after 4 weeks, my lord, subject to your lordship's
on उसमें और करो. If the deed is corrected in terms of the above direction, the petitioners are directed to who will register the deed, board or petitioners?
Actually, the board will have to be present there, and it will be registered before the registration authorities. Their authority will be there for that purpose.
Directed to execute the said deed
after correction, after the corrections.
The said deed after the corrections, and the board is directed to make necessary arrangement for registration of the same. Leave the matter on 23rd July 2026 under the same heading.
I'm grateful.
The supplementary affidavits filed by the parties be kept with the record. Do that.
Sorry to keep your lordship waiting. I'm great.
Virtually, my lord. Only one repetition. Only one thing that I want to indicate, the next election is due in August 2027. So, my lord, yes, my
No,
lord,
Milord, what may I make this submission, Milord, before your lordship?
Yes, yes.
Milord, there is an application where we wanted, Milord, the forensic, the examination of the, Milord, the ballot papers. We don't want to go ahead with that, Milord. We find that there is enough material to show, Milord, that the election itself is bad. So lordship fixes any day your lordship pleases, Milord, but it will take a little bit of time, but not much time. I can assure your lordship that. I have two very important points which I may indicate before your lordship right away. The first one is, Milord, the person who was supposed to, Milord, carry on with the election did not have a right to carry the election. The special officer, Milord, who was appointed by this honorable court, and Milord, all the records were, Milord, were kept, have found, or rather has found, Milord, irregularities in the voting process itself. So those materials itself will be good enough to show, Milord, that the election was bad. So forensic, Milord, will take a long time. We are not pressing it. Whatever evidence we have on record, we are quite, Milord, in a way, we would say, Milord, confident about the election not being in a proper manner. So
Which
kindly calls for all the records, Milord.
application is the
Can 2 filed in connection with WPA 23380 of 2022.
and what is can 1?
Can 1, Milord, I'll tell you lordship right away.
Disposed of, and 1 is not there.
Can 2 affidavit filed.
Yes, affidavit.
Reply, my lord, I'm filing.
So you are filing reply. So that is to be disposed of as not pressed. And West Bengal Council submitted, there's no direction in connection.
I need this only records, Milord. It's on instructions. It's not on our. It's on
Correct.
instructions.
2336 and 23 for filing affidavit. Affidavit in opposition, both the writ will be filed. So
But may I make this submission, Milord? If your lordship keeps all applications and the writ petition together on a particular date, so everything can be thrashed out on that particular date itself. Because
but if the can 2 be kept pending, then at the time of hearing, then it will be difficult.
I will not press it. I will not press it on that day.
2330.
Because I will get a letter in writing, Milord, that they don't want to press it.
No, then with regard to the main application, main writ application, there are 3.
Yes, Milord.
3 writ petitions.
Yes.
23306 affidavit filed.
No.
You are time on the last occasion, Mr. Singh.
The name I can. Yes, Lord, I.
23306 and 23380 filing affidavit press for time.
23439 affidavits are complete.
No, last occasion by an order dated 1st April, there is a direction for filing affidavit in opposition.
They have not filed yet.
Dr. Aduri and Dr. Uzi Rajguru. 23306 and 23380. Those are pending.
23306, Dr. Arjun and Dr. Biswajit.
Yes, those are pending.
So you are not prepared the affidavit.
I have heard, but they have not been affirmed.
Milord, the affidavit in 1 would suffice the affidavits in all. They have filed their affidavits in some matters, Milord. The issue is on the records only. There's nothing beyond that.
To Dr. Sukanti Bhattacharya, already done. Reply also filed.
Yes.
Even in the last one is also done.
Wait. So now only with regard to 2380 and 2330. You want
They have not
how?
filed reply in the last one, 24183. Yes, my lord.
You will.
I'm not. We are not appearing in that matter. That's a separate matter.
You are appearing for only 2 matters.
3 matters.
3 matters, Milord.
For 183, you are not appearing.
No.
And
Milord, if you see the last order, it's written there, Milord, in which matters we are appearing.
yes, you are not up 2 weeks. Learned Counsel for the petitioner in WP number 23380 of 2022. 2022. On instruction, submits that though the petitioner has filed an application being Can 2 of 2023, praying for forensic expert report, but now the petitioner is not interested to proceed with the forensic expert report, and the petitioner intend to not press the said application. In view of the submission made by the counsel for the petitioner on instruction Can 2 of 2023 in WPA number 23380 of 2022 is dismissed as withdrawn, as not pressed. Full stop. Learned Counsel appearing for the you are appearing for the West Bengal Medical Council, press for extension of time to file affidavit in opposition in connection with WPA 23306 of 2022 and WPA 23380 of 2022. Let affidavit in opposition be filed within 2 weeks. Reply, if any, be filed within
1 week, my lord, maximum.
Thereafter. Learned Counsel for the petitioner in WPA 24183 of 2022, prayed for extension of time to file affidavit in reply to the affidavit in opposition. Let affidavit in reply be filed within 2 weeks. Let all the matters be placed before this court.
For service of the state.
Full stop. As none appears on behalf of the state, the Learned Counsel for the petitioners are directed to inform the next date of hearing to the office of the government pleader so as to enable the government pleader to engage the panel advocate to appear in the matter on behalf of the state. Please the matter 11th and 12th August 11th and 12th August 2022 at 1 day is enough. 11th August at 2 p.m. as especially fixed.
Only one thing, kindly record. We are not pressing that application because it will delay the proceeding. Kindly record that.
That's sir.
On instruction.
As instructed.
Because due to the said application, the writ petition is getting delayed. Hearing of writ petition is getting delayed. Okay.
Grateful, Your Lordship.
Next.
I am for the petition in this matter. Well, the petitioner was supplier of benzoyl benzoate as a drug in favor of the respondent company. We supplied it in 2024, and
I'm appearing for.
My lords, in this matter, I am appearing for the respondents, my lords. On the first day of hearing, my lords, I have raised certain preliminary objections with regard to the maintainability of the petitions. Lord, there exists an arbitration clause. The petitioners has challenged.
Yes.
May I, my lords?
Yes.
My lords, on the last date, my lords, the petitioners have challenged the blacklisting order before this honorable court, my lords.
Yes.
And there exists an arbitration clause which specifically provides, my lord, that all the disputes will be referred to the arbitration. Therefore, my lords, there is a preliminary objection with regard to the maintainability of the petition. Otherwise, there is no issue. It's a pure commercial issue. Blacklisting order has been challenged before this honorable court.
Yes.
Therefore, they must go to the arbitration, my lords. The petitioners are saying
because was we've taken care of the same on the last occasion. Again, I shall be making my submission.
The petitioners are saying that it's a drug and cosmetic act, which is a special act. Therefore, the arbitration act will not apply, my lord. To my respectful submissions, my lord, it's a pure commercial dispute. They have supplied drugs
What I say,
testing,
let me say,
during trusting
if not in the mouth
that
of
was
the
not
respondent,
found of
what I
standard quality, and therefore, as per the terms of the contract itself, after giving due opportunity of hearing to the petitioners, my lord, they have been blacklisted. Therefore, my lords, no question of entertaining the writ petition before this honorable court, my lord.
Okay.
The other objection which I have raised is with regard to the territorial jurisdiction, my lords. The contract in this matter has happened in Uttar Pradesh. The drug has been supplied in Uttar Pradesh. The order has been passed in Uttar Pradesh. Even otherwise, in contract, the courts that there is an exclusive jurisdiction clause between the parties. Therefore, my lords, on that count also, my lords may not be pleased to entertain this writ petitions.
Yes. Yes.
Yes. May I, my lord, give the answer to the last question first? Regarding the jurisdiction, all communications were made in West Bengal and rejection of or blacklisting of this company has been, my lord, communicated here in West Bengal, and supply was regulated from West Bengal. Therefore, cause of action has arisen in West Bengal. Therefore, the West Bengal, my lord, has got as a jurisdiction to receive, try and entertain this. And so far as the arbitration clause is concerned, my lord, this Drugs Act, my lord, is coming under the purview of the, they have blacklisted me, prosecution will lie against me, my lord, alleging that spurious drugs have been, my lord, supplied by us. My lord, that particular issue, my lord, is covered by the criminal law, where the people, and that they are saying that is not of standard quality. If it comes under the criminal law, my lord, the question of arbitration, my lord, that cannot solve the issue. The issue was, before your lordship, was that the materials were supplied during, as per the order of 2024 December, during 2025, huge quantity of materials were accepted. This particular company, is in the receiving end, my lord. They are procuring the materials and distributing someone. They are not, my lord, at all, my lord, using it for their own. What they have done, my lord, that materials were liable to be tested in laboratory of the Government of India laboratory. It was tested in the laboratory, and laboratory reports were supplied along with the goods we supplied. Yeah, benzyl. But according to the rules and regulations, that particular materials can be having a second test by the procurer by appointing a drug inspector according to the statute. In the present case, after the receiving the materials, at the time, when we raise the bills,
where is the impugned order?
The order impugned is in the application, my lord. Lordship, in the writ petition, it was missing, my lord. You omitted at application for appropriate order can 1, my lord. The same was, my lord, annexed to a lordship's petition. Lordship may kindly come to this page 10 of the application for appropriate order. Impugned order is 29 January 2026.
Yes.
This was the impugned order. This runs about, my lord, about 30-35 pages. First paragraph is, only the defense that was our status and our case has been made out here from at page internal page 20, whether probably it is page 20. It has been written, the case made out by the supplier. We are the manufacturers. That runs for few pages. Ultimately, my lord, from they have, my lord, have their own decision from page 28. From page 28, they have shown their decision. The fact, my lord, after the, my lord, recording, the fact has not been, my lord, am I correct, my lord? Has the lordship followed it? The fact has not been disputed, denied by the company that during the confirmation testing of the drugs by the empanel labs, the batches supplied by the company did not meet the requirement of acceptance of criteria of microbiological testing of non-sterilized product for pharmaceutical use. As my case was that microbiological test is not required as per the statute so far as the non-sterilized product supplied by the petitioner is concerned. That is the statutory norms. I followed it. My laboratory testing report was given along with that. They have removed our level and privately appointed some local laboratories for the purpose of microbiological test. They found that there is a negative report against us, not up to the standard. Then microbiological test report goes for that. Kindly, the Indian pharmacopoeia, it does not prescribe any microbiological test so far as this particular item supply is concerned. That is also, we have disclosed in our affidavit in reply. The rules itself is a part of the court's order. And secondly, after I have supplied 126 batches of goods, where 26 batches, more than 100 batches we supplied, 26 batches were found to be not satisfying the requirement of microbiological test, if that is accepted by the court ultimately. And I have been blacklisted. Penalty has been imposed against me. But this testing has been done by the persons without asking the inspector to come and to test it. They have no jurisdiction to, on their own, send it for microbiological test. That is there in the drugs rules, at 5A, clause 2. May I hand up to your lordship the drugs rules? That is also there in the supplementary affidavit. Supplementary affidavit in reply. In our affidavit in reply. Drugs supplied by a hospital or dispensary maintained or supported by government or local body. Clause 2. The premises where the drugs are supplied, the stock shall be open to inspection by an inspector appointed under the Drugs and Cosmetics Act, which they have not done. And these drugs have been identified to be an ex parte order was passed.
Yes.
Ex parte order was passed, which was set aside by this honorable court. Rather, the court said, I do not know, the court was of the view that the order should be kept in abeyance and opportunity of hearing should be given to me. I was had to make a representation again and opportunity second order that is impugned to your lordship's court. These aspect has not been answered or addressed by the authority in their order. It is not, no inspector was appointed. The supplier has on his own sent it without giving any intimation to the petitioners.
Yes.
Yes. The supply was spread over. I am a existing supplier from 2022 onwards. This item was supplied without any microbiological test. It was not required at all to be done. My first point before your lordship, the microbiological test is not required according to the statute in respect of the goods supplied by me. My second submission to your lordship that
what is not required?
Microbiological test. They have done it through private laboratory. My second one is, before you decide to take the microbiological test, you should have given me a notice and in my presence.
Why the microbiological test is not required?
According to the statute, this particular item is not required to be tested by the under Indian pharmacopoeia. দেখাচ্ছিলেন তো রুলসটা আমাকে এক্ষুনি এইটা কেন যেটা দেখাতে বললো no microbiological test is required.
Cutaneous, এটাই হচ্ছে cutaneous there is no specification.
ওইটা বার করুন না বইটা. My lord, kindly come to my lord. দেখালেন দেখুন in my affidavit in reply বইটা দেখালে রুলসটা দেখালেন তো এর সঙ্গে তুলে দিয়েছেন. That we have already stated to your lordship, my lord. The drugs rules have been given to your lordship. Mala that is the inspection, so far the inspection part is concerned, at the schedule kore, jeta microbiological test lage na. Mala, this particular item, mala, which was supplied by us is coming within the definition of cutaneous use. Cutaneous use, mala, does not require any, mala, microbiological test. As per Indian Pharmacopoeia, the relevant page is, mala, kindly highlighted portion is there. Excuse me for the same. দেখাচ্ছিলাম তো আমাকে। May I consult the book for once? ওটা কোন জায়গাটায় বার করেছিল? ওইটা বার করে দিন না, মাইক্রোবায়োলজিক্যাল টেস্ট লাগে না বলে দেখালেন যেটা। Form 36 form, yes. Yes. We apply under Form 36 for the license, and that particular application for grant of approval for carrying out the test, and the category of drugs have been mentioned, and microbiological test, mallard, only has been, mallard, mentioned against drugs specified in Schedule C and C1. I come under Schedule 2. Kindly come here. Schedule 2A.
I do not understand what you want to submit. What is this case? It's going somewhere. What is your case? You referring one document, then you are referring other document. I not understand what is your case.
My case is that
you are submitting.
my case is that my microbiological test you cannot do in respect of the goods I supplied. My first question.
First of all, you show me the where is the this arbitration clause.
Arbitration clause
Why
in the agreement.
arbitration is not it's not cannot be invoked.
Well, that is in the agreement itself, my lord, that is there.
Show me. First you conclude, come to the mentality point.
It is on page 80.
Well, it starts from, yes, page 80.
What is your answer to that?
First, it comes under clause 3 in case of dispute or difference arising between the tender inviting authority, purchaser and the bidder, supplier relating to any matter arising out of the connected or connected with the contract, such deposit or difference shall be referred to as sole arbitrator as mutually decided by the parties. The fees should be.
Yes.
Well, this particular issue, my lord, was my lord, considered at the first initial stage when I filed the writ petition. There also, my lord, the question did not arise. The court set aside the said finding.
Where is that?
The first order of the court.
Where is that?
First order ta kothay or amader Amrita Sinha order ta kothay? Yes, my lord, that is at page 186. That is at page 186. That is second volume. There the issue has not been, my lord, adjudicated. The first order, my lord, where I was held, my lord, blacklisted, my lord. That order was subject matter of challenge, and the court said that you go and give an.
Okay, that was not issued. That was mentality is not raised here.
Here the mentality was not raised. There
yes, you stated that already been set aside, already been decided. Where is that decision? There is no decision.
No issue was raised here.
Correct.
No issue was raised here. But they have accepted the position. Yes, the High Court has a jurisdiction. They have not raised that issue.
That was decided only consideration. Now the matter has to be heard on merit. Now they have taken the first decision with regard to the mentality of the arbitration clause. What is your answer to this? Why the arbitration is not applicable?
Because Drugs Act itself is a criminal act, my lord. And if the criminal act, my lord, any wrong is committed by anyone, allegation is made, my lord, that cannot be decided in arbitration.
Why? You have challenged the order of blacklisting. Blacklisting order has been issued on the ground that the materials, the drugs which you supplied, that has been tested in one of the laboratory, and it is found that it was the standard was not up to the mark. That's why the so-called notice was issued and it was issued. And you have been blacklisted and tender was cancelled.
In blacklisted, my lord, I have not been paid the amount of money which is due and payable above what goes over 1 crore. Goes over 1 crore, but that is supply in respect of
blacklisting. What has happened to the contract? Contract was issued to you.
Contract, my lord, is remaining still valid, my lord, but they are not applicable to me now. Now they are not accepting any goods from me.
Now where is the if the tender was cancelled?
No, tender has not been cancelled.
Then
tender not been cancelled.
So
Contract has not been.
What has happened to the tender?
Tender we supplied as per the tender, as per the requirement we have supplied.
The authorities have published the tender notice. You have participated and you have been awarded the contract.
My lord.
And you have supplied the materials. Materials which are supplied, it was found that the
some of the material, not the
correct,
entire.
some of the material, it is found that it is not up to the
conforming to the
correct
standard.
Conforming to the standard. Now the blacklisting has been issued. You have been blacklisted. What has happened to the contract?
Well, contract, we are asking for the payment in respect of the other items also.
Payment is different thing.
Contract supply is not being made now.
What is the total supply? You have supplied the total? Or
yes,
not?
total supply I have already made. Total supply, 1 lakh.
Because the impugn order does not say that it has been terminated. So whether the total materials have been supplied by you and that has been taken sent to the foreign and the
microbiological test.
Yes.
No. Then? Only 26 batches have been found to be. It goes over 100 batch.
Where is that? Where is the work order?
Work order.
They are determined. That's what should I. Article
যেটা বলছেন টোটাল কন্ট্রাক্টটা কত ছিল?
Where is the work order?
Work orderটা কোথায়?
Different time, different work order.
Different time, different work orders were given, my lord, against which the supply was made in phases. We have given supply in phases.
Where is the tender notice?
So, tender notice is annexed to the petition. Kindly come to page 174. That comes at page
because they have
page 51. Page 51, volume 1.
That is the tender notice. Where is the tender? Where is the work order issued to you? Yeah, rakhe rakho na.
But tender was accepted, and accordingly, my lord, work order was being sent to me over the mail. Over the mail, and admittedly supplied was accepted. There is no dispute to that. And there are dispute with regard to the supply, my lord. They have impugned order itself will accept.
With regard to the, they are telling with regard to the jurisdiction. You are telling that the correspondence has in. Where is the correspondence?
Kindly come.
Where is the work? That's why I'm asking. Work order only. So the work order has been issued to your office at Calcutta. Where is that? How you justify with
no. Correspondences have been made, my lord.
Where is that?
In Calcutta.
Where is that? So
all correspondence, my lord, have been sent to Calcutta by the said authority.
So.
Kindly come to, my lord, page 192. Hearing notice. That was given to Calcutta, our Calcutta office.
That is hearing notice. Where is with regard to the other?
And improved
so-called-
order itself also was communicated, my lord.
Sir, you have participated in the tender. From where you have participated in? From Calcutta or you went to the Uttar Pradesh? And after the participation of tender, the work order might have been issued. Where is the whether work order was issued to the Calcutta or in Uttar Pradesh?
My office
Then
in
you
Calcutta.
supplied.
I
When
have
you
no
supplied,
issue in Uttar Pradesh.
show me.
My registered office is in Calcutta.
Might be.
They have all communication made in Calcutta.
Show me. First you have to establish, sir. How you prepare the writ application without giving any facts?
Facts have been given, my lord, page 40 of the volume 1 of the writ petition regarding the jurisdiction point.
You have to show the document. Where is the first cause of action? From the cause of action is with regard to the work order. Where is the work order issued to you? On where what is the document? You have supplied the materials from West Bengal to Uttar Pradesh.
Admittedly, here from Uttar Pradesh.
So, not admittedly, they are raising the objection with regard to jurisdictional point. Show me.
So far as the contract is concerned, my lord, that is at page 112, the contract has been entered into letter of that this is the standard form, my lord, the contracts form, page 114. And this is in 2024 execution of the agreement of deposit. My lordship will kindly performance supply. The letter has been given by Uttar Pradesh to our Calcutta office.
Where is that?
At page 119. Execution of the agreement and deposit of the performance security for supply of the drugs to Uttar Pradesh medical supply. Page 119. Volume 1.
Then
next page is the agreement, page 121. Agreement is made on 11th December 2024.
where you issued the bank guarantee?
Bank guarantee of West Bengal.
Calcutta or Uttar Pradesh?
From Calcutta.
Where is that?
Calcutta. Kindly come to the agreement itself, my lord. Also, we signed it from Calcutta. Our address is shown in Calcutta. At page 121, 11 page 122 top.
How you can say this has been executed in Calcutta? Where it is mentioned?
That is that notary and Alipur. Kindly come to page 124.
Notary Alipur, yes. Yes, then where the bank guarantee was issued, which bank? Calcutta?
The letter of guarantee, page 125.
Which bank guarantee was issued? Kolkata?
Punjab National Bank.
Where? Punjab
Bank
National
guarantee
Bank?
for performance. But bank guarantee, kindly
branch.
come to page 126.
Rajanga branch?
Yes.
Kolkata?
Punjab National Bank, Bospukur, Rajdanga branch at the bottom, page 127 or 126, Lordship will get it.
Yes, then, okay, no. Now, what about the arbitration?
But I I stand on the question of arbitration on the because of the fact, my lord, the dispute that has been, my lord, raised in the present writ petition is with regard to non-performance of statutory duty by the authority. Okay. It is a statutory obligation. As per the statute, they deviate from the statute and they exercise some power, my lord, which is not conferred under the statute on them.
Okay.
Kindly, my lord, come to my affidavit in reply forwards.
And what, yes, affidavit in reply,
Yes,
what you want?
page 2.
Yes.
Paragraph 4. A. The Drugs and Cosmetics Acts and the Drugs and Cosmetics Rules are considered a specialized self-contained legislation that prevail over the general law like the Indian Contract Act and Arbitration and Conciliation. In matter relating to manufacturing, sale, quantity.
Okay, what about the merit? What about the merit?
Now, merit.
Yes.
In merit, my lord,
Where is the so cause notice? Where is the so cause notice?
Yes, first show cause and second show. I will show you, your lordship. The show cause notice was given. My lord, kindly come to page 9. Cause was 26 batches not of standard.
Page 9.
16/7/25. 16th July 2025.
Which page? Where is the so cause notice?
First show cause. 158. কি ভুল লিখেছি আমি এখানে। Page
Not of standard quality.
Not of standard quality.
What is the clause in the agreement with regard to the quality? What is the clause in the agreement?
According to the statutory rules.
No, requirement there is no IP.
Page 80, requirement no IP.
No, what is the
80?
How the quality is to be, where is that? In the tender notice, where it is mentioned with regard to the quality of the material?
Kindly come to page 85, schedule of requirement.
85?
85 of volume 1.
Yes.
Schedule at the bottom one, 39 clause, Benjamin, serial number 39, benzyl, benzoate, application 25% so and so, Malar estimated annual quantity has been mentioned and minimum shelf life required is 24.
So this is the
for 24 months.
This is the subject matter.
Yes. This is the subject matter. This is no official compendium has been mentioned
in the
except in the requirement. Only the law that is prevailing over the issue is to be governing the issue.
This is with regard to the benzyl benzoate application 25% WW. What is WW? 100 ml bottle, 7,400, 7,44,000, 24 months. You are concerned with only one medicine?
Yes, I am concerned with only one medicine.
Yes.
But we gave a reply to this show cause also, my lord, on 21st of July 2025. And second show cause was also issued, my lord, at page 227. Second show cause also was issued. To which, my lord, we have given a reply as 230.
Now you come to the page 167, 167.
Yes, my lord.
167. The following tender conditions as per the tender UPSC rate so and so applicable in respect of supply of UPMSCL, which is declared as non-substandard quality. Condition 11. Where is that?
Following tender conditions as per the tender so and so are applicable in respect of the drug supplied by UPMSC, which is declared as not of standard quality. Condition 1, that quality
Condition 11,
corresponding to
condition-
NSO batch shall be deemed as non-supply, flat 20% penalty levied. Condition number 11.
Where is the condition?
Condition. Huh? That is in the tender clause.
So that's why asking you are not, you stated that there is no further condition. Yes, quality assurance. All supply has to be accompanied by the batch-wise test report from NABL.
Yes,
75, sir. Kindly come to the
that you supply. That you supply with the report.
They don't have any license to test microbiological test.
And this authority whom they have got it tested for microbiological had no license to have a microbiological
Correct,
test.
correct. I will come to now. Kindly come to the page 75. This is the quality assurance. Correct.
Yes, correct.
So they are telling that 11, violation of 11.
Yes.
11.5. Quantity corresponding to NSQ batch shall be deemed as non-supply and flat 20% penalty shall be levied.
My lord.
What is the answer to the 168? Kindly come to page 168. Where is the answer to the so-called notice to that?
Yes.
Where is the so-called reply?
168 of the so-called notice. Condition so and so in case of the batches. Condition so and so in case of the supply does not take the stock of NSC.
Now come that with reference to the above, you are by directed to explain.
Explain why as per the condition so and so.
So 1, 2, 3, 4.
1, 2, 3, 4.
Correct. Explain as to why the condition number 1, tender supply quantity drug batch number so and so should not be treated as a non-supply of payment of.
Yes. Malad, kindly come to page 221.
221.
Page 221 for once of the writ petition.
State drugs control and research.
What is there on their microbiological test only? That is a fault. We are in fault. Kindly come to the State Drugs Control and Research Laboratory report.
221, yes.
Government of West Bengal, page 221.
Yes.
That is of 2025. The test parameter of benzoyl application 25% as per the Indian Pharmaceutical Pharmacology monograph and journal chapter. Microbiological contamination of non-sterilized product does not include any microbiological test.
Correct.
So what they have done, my lord, absolutely, my lord, on their whimsical decision, on their own novation, my lord. They have not, my lord, followed the guideline given by the drug controlling authority, the government authority, with regard to the item supplied by us. Now, this does not, my lord, conform to our requirement of any microbiological test. That too has been done from a private laboratory.
How you come? How you are telling that the microbiological term? Kindly come to the what is their allegation? 167. After supply of sample of drug batch number so and so. Kindly come to the 167, third paragraph, read paragraph 3.
Yes, 167.
167, paragraph 3.
Yes.
So after
167.
uh,
The following tender condition.
167 after supply.
After supply.
That paragraph.
Yes, yes.
Read it.
After supply of the drugs batch number so and so was sent to Sri Balaji Test Laboratory, MPanel Laboratory, has declared batch number so and so not standard quality for conform.
So it is not standard quality. So that's why I'm telling. Please stop here. So it is a not standard quality.
Right.
So how you are comparing with the microbiological contamination? What is the not standard quality?
That is
due to failure of microbiological.
only because the microbiological.
Where you are getting? That's why since beginning you are telling that. So where you getting?
The test report.
Kindly look at the test report. Okay, test report. That was also not even inspected by an inspector.
You show me
They have sent it
where this not of standard quality was taken into consideration because of the microbial
That is
contamination.
Page 158.
Page 58 the notice.
158.
158 the notice. Socos notice. Start Socos notice. You are not ready with the total brief. By this time, I have gone through the total brief, but you are not ready with this.
171.
You on
171.
the SEMA lab. Where is the Balaji report?
Opinion.
Not opinion. Where is the Balaji report?
Opinion of the undersigned. The sample notes not standard quality in the.
Where from you got this report?
As defined under the rules made.
Yes.
They are under for microbiological examination.
Where from you got this report? Where from you got this report?
UPMSCL sent.
The authority has respondent have said.
Where
that
from?
is the report they have sent.
No, report kindly come to the 170. This is the SEMA lab. Kindly come to the Sri Balaji test lab. 170.
Yes.
Can you read the 170? I can't read.
The opinion.
It is a microbiological test.
This is also one of the microbiological test report.
Because as per the 158 Socos notice, they have sent your all materials to Balaji.
No, not only Balaji. This is also another.
26 there.
Three companies. It was said. 3 laboratories.
Sophisticated industrial
And
material.
Balaji has its own report at page 226.
Okay, come tomorrow.
Against Malad.
Come ready tomorrow. Come ready tomorrow. The counsel for the petition argued the matter at length, but due to paucity of time, matter could not be taken up hearing. Let the matter appear tomorrow.
My lords, can we have this matter day after tomorrow?
Day after tomorrow.
Most obliged, my lord. Most obliged.
Keep it then Friday. After tomorrow, we have some difficulty.
On 19th. Come with the total gist.
Yes,
What
yes.
is one? Where is the report? Where is that?
I'll give a clear picture to you.
Yes, give the report.
Most obliged, lords.
Next. Yes, 5:30. Every day you are mentioning this is not the time of mentioning.
Your Lordship, may I be allowed to mention a matter? Lordship, it is appearing at item number 141 today. I am praying for upgradation of a matter appearing at 141 today of the original site, Your Lordship.
Which serial number your matter is to be fixed?
140.
Tell me this code, which serial number matter is to be fixed? Which date is to be fixed?
I cannot definitely say that,
Then?
Your Lordship, but there is some urgency.
What is urgency?
Lordship, the case is regarding non-production of document by the state authorities, Your Lordship. Non-production of document by the port authorities, Your Lordship. Our prayer is only that they had in writing, in 18th of February, they had stated they will produce us some documents regarding 13,000 metric ton of coal being vanishing from the port authorities, Your Lordship. So we had intimated to the port authorities. They had in writing stated they will provide us the documents on 18th of February. Your Lordship, 4 months have passed, Your Lordship. They have not yet provided any document. That is all our matter is.
When the matter is taking up, you persons are, my senior is busy, when senior is busy. When the matter is listed, then you are coming, then I will fix tomorrow, then you will be coming with my senior is busy with the court number 48, court number 36.
No, Lord.
Come, you wait. Yes, call the list. Yes.
But I've been trying to fix my case at 3 p.m. For a long time. My lord, kindly fix it at your lordship's earliest possible.
What can be done? 2 days I have fixed.
No, anyway, any day.
When which matter?
9:14.
Huh? 9 is there. Please wait. Please wait. Yes. Call the list.
Item number 1, content with.
I am for the petitioner, Your Lordship.
I have dismissed the writ application, but the respondent authorities have directed that the petitioner already filed the reply to the so-called notice to consider the reply without being influenced of any of the observation made in the order. And if the petitioner intend that he may be given an opportunity, personal opportunity, that's the same may be provided.
Item number 2, specially fix the case.
It's for witness action.
Yes. Present. Witness present.
Yes.
You speak English?
नहीं, हम मिला के बोलेंगे सर, हिंदी ज्यादा.
What's your name, sir?
रमेश कुमार केजरीवाल.
Ramesh Kumar Kejriwal.
Cross examination.
Yes, we'll start the cross.
Start with it.
Oh, I think 2 questions were put on the note. Just a minute.
धीरे धीरे से बोलिएगा, ठीक है?
How are you? Oh, sorry. Connected with the company named Sri Hanuman Cotton Mills Private Limited.
श्री हनुमान कॉटन मिल्स प्राइवेट लिमिटेड, इस कंपनी के साथ आप कैसे संपर्कित हैं?
सर, हम उस कंपनी के डायरेक्टर हैं.
I am the director of that company.
Do you remember that this company was at a point of time struck off by the Register of Companies?
क्या आपको याद है एक समय रजिस्टर ऑफ कंपनीज के द्वारा ये कंपनी को स्ट्राइक ऑफ किया गया था?
सर, ऐसे तो हमको अभी तो चल ही रहा है कंपनी सर. 20
आपको याद है या नहीं है?
मैंने सर, ऐसे तो हमको ध्यान में नहीं है, पर कंपनी चल ही रहा है सर.
I do not remember. The company is still going on.
मैंने आरओसी में है अभी.
ठीक. Wait, the volume 1. Getting marked over there. I suggest to you that sometimes in the year 2014, this company was struck off by the Register of Companies, and for its revival, you had filed a proceeding under section 560(6) of the Companies Act 1956. What do you have to say?
सर, यदि फाइल किया है तब तो सही होगा, पर इसमें तो.
If I had filed something, then it is true.
It's true. Shown वॉल्यूम 1 पेज 68 देखिए ना ओ पीडी 9 pages 68 to 70 of the judge's brief. Being an order passed by this honorable court dated 23rd of December 2014.
68 to 70.
Will you agree with me that this is one of the orders passed by this honorable court in connection with CP number 982 of 2014, 982 of 2014, in a proceeding under section 560, bracket 6 of the Companies Act 1956.
क्या ये उस मामले का एक ऑर्डर में से एक है?
हाँ सर 982.
Yes.
Yes. You will find that there are certain directions passed by this honorable court as recorded in the order, particularly at the second paragraph of the second page. I believe that these directions were complied with.
जो डायरेक्शन दिया गया था इनको कंप्लाई किया गया था.
सर ये बैलेंस शीट जमा करने के लिए बोला गया क्या?
देख लीजिए उनको पूछो उनको. Yeah.
थोड़ा जोर से बोलिए.
Sign है. Just ask him.
सर ये हम लोग आरओसी में जमा तो दिया था बैलेंस शीट ये सब, पर इसमें सिग्नेचर
We have submitted all the documents to the ROC, Register of Companies. बोलिए. Register of Companies.
भाऊजी का सिग्नेचर के बारे में हमको ध्यान में नहीं है सर.
I do not remember anything regarding my father's signature.
The order records that you were required to take the signature of Murari Mohan Kejriwal on the balance sheet of the company and then submit the same before the Register of Companies. Was that done?
आपको समझ आया प्रश्न?
मैंने वही सर सेम आंसर है सर. हम लोग जमा तो दिए थे, अब उनका सही था कि नहीं हमको ध्यान में नहीं है सर.
We have submitted the documents, but I do not remember whether my father's signature was there in the document or not.
No, ठीक. I suggest to you that the signature of Murari Mohan Kejriwal duly appears in the balance sheet of the company, which was filed before the Register of Companies pursuant to the order dated 23rd of December 2014.
ये आपको सजेशन दे रहे हैं कि आपके पिताजी का सिग्नेचर उस आरओसी में था. आरओसी के सामने अपने जो डॉक्यूमेंट दिया था उसमें था. कि आप मानते हैं या नहीं मानते उनको सजेशन को?
सर ऐसा हम पहले बोला ना, हमको ध्यान में नहीं है सर. मैंने
आप मानते हैं या नहीं मानते? Do you agree or disagree?
हमको याद नहीं है सर उनका सिग्नेचर है कि नहीं.
I do not remember whether the document carries his signature or not.
Do you remember of filing any appeal from this order?
आपने कोई अपील फाइल किया था इस ऑर्डर?
अरे इतना केस हुआ है, ध्यान में नहीं है सर. बहुत केस हुआ है सर.
But it's an order of court, my lord. We have not exhibited the order of this court, so we have not exhibited. Sure.
But Mr. Chaudhary is disputing the order of the court.
Joseph, onno kotha bolchi. It's an order of this. We have not exhibited the order. Order.
No, I inform you, you are disputing the order.
Disputing the order only. The existence of the order.
Samadha Saheber order.
I've seen recently. An appeal, one in the appeal. Consists of extinguished argument based on extinguishment of right of the defendant based on a decree of the Alipur court.
Jali di?
Yes, yes, it's a forged. There is no such suit, there is no such decree.
হ্যাঁ, একটা কাগজে কাগজে বেরিয়েছিল। কাগজে চুপ করে যাও এবার। এবার চুপ করে যাও ভাই। না না এক্সিবিশন
Yes, next.
Yes, ma'am. Will you agree with me that না একবার এটা দেখেন ভলিউম 5 এক্সিবিট QQ shown exhibit QQ being pages 1316 to 1334.
1316 to 1334.
Kindly tell the Honorable Court the date of these documents issued by Apollo Gleneagles Heart Center.
ये जो डॉक्यूमेंट्स है ना, इनका तारीख बताइए।
सर ये 1316 में डेट है 14 अप्रैल 2010।
The document appearing at page number 1316 is dated. The document appearing at page number 1316 is dated 14th April 2010.
अच्छा 1317 में भी सेम डेट सर।
Document appearing at page number 1317 2010.
14th April 2010.
The document, sir, the document appearing at page number 1317 bears the same date. Is of the same date for the answer, Judge.
29, yeah.
Of the same date. Is of the same date. Sir.
Up to 1329 বলেছিলাম না?
34
ঠিক আছে
सर ये 1329 तक अप्रैल है।
कहाँ से 1329 तक?
1318 से।
14
page number 13182
1329.
1329.
1329 are dated 10th. What is the date?
14th April.
14th April 2010.
सर ये 1330 में 16 मार्च है सर।
16 मार्च
2010।
The document appearing at page number 1330 is 16th March 2010.
और सर 1331 में 1st May 2010 है सर।
The document appearing at page number 1331 is 1st May 2010.
10
सभी 10
और 1332 में है 8th May 2010।
The document appearing at page number 1332 is dated 8th May 2010.
और सर 1333 में है 10th May 2010।
The document appearing at page number 1333 is 10th May 2010.
लास्ट सर ये 1334।
The document appearing at page number 1334 is dated
21st May
2010.
You will agree with me that Dr. Arun Mullaji, whose receipts are appearing at pages 1330, 1331
and 1333 and 1334 was the doctor at Breach Candy Hospital, Bombay, who treated your father for operation of his knees?
Yes, sir.
Now kindly look into the documents from 1316 to 1329. 1316
29.
1316 to 1329. Now you will also agree with me that in all these documents, which are receipts issued by Apollo Gleneagles Heart Center, the name of the doctor is appearing as Arun Mullaji in the bottom left.
तो नहीं क्या इन सब डॉक्यूमेंट में जो डॉक्टर का नाम है वो अरुण मुल्ला जी है? देखिए
सर ये 1316
to 1329
हाँ ये अरुण थोड़ा सा लिखा हुआ है,
लिखा है,
अरुण मुल्ला जी।
देख लीजिए एक बार।
देख लीजिए एक बार।
हाँ ये अरुण मुल्ला जी।
1316 to 1329
क्या मिलाडी ने क्या लिखा, वही होगा सर, अरुण मुल्ला जी होगा सर। जीरोक्स में ठीक से नहीं आया ना, वही होगा
देख के बोलिए सर।
सर। आप ही देखिए ना, आलोक मुखर्जी लिखता है।
It's not that
वही होगा सर।
photocopies multiple times.
वो होना चाहिए, वही होना चाहिए सर।
I suggest
इसमें तो काका जी लगता है सर। देखिए आप देखिए, वही होना चाहिए सर।
Yes, next.
Yes. I suggest to you that the documents issued by Apollo Gleneagles Heart Center, which are dated 14th April 2010, are pre-surgery diagnostic tests for blood and X-ray of your father.
कौन सा पेज में सर?
ना बोले नहीं ऑपरेशन 1316 to 1324 sorry 29 are pre-surgery routine tests for blood and X-ray.
Sir
1316 to 1329
29 है।
The exhibited document.
Yes.
ये सब
Exhibit
ब्लड
Q-
रिपोर्ट और
Q-
एक्सरे है,
exhibited.
राइट?
हाँ बड़ा
सर एक में तो लिखा हुआ है ब्लड बैंक आपका, ये 1321 में, बाकी में और सब क्या क्या सब लिखा हुआ है सर। आप देखिए 1321 देखिए सर,
1321 हाँ
हाँ सर। 1322 में रिस्पायरेटरी में क्या लिखा है सर?
This blood group and RH typing.
हाँ सेटा वो ठीक है सर,
Positive negative है।
सर 22 और 23 में दूसरा बात कुछ लिखा है सर।
So she will kindly say down with this blood sugar and other things which are there.
ठीक है,
ये सब ब्लड का ही
Blood
test है।
sugar, blood urea, creatinine,
22 में
fasting and
रिस्पायरेटरी
the
क्या
other
लिखा
one.
है?
इसका आंसर क्या है? यस
ठीक है सर।
Yes, next.
यस बोल दो।
ठीक है। Yes, good. You will also admit with me that the knee operation, that the right knee operation of your father took place at Bridge Candy on 8th after 8th May 2010.
तो ये कहीं पता चलेगा इसमें?
No, it's a suggestion to you. Do you admit with me that the operation of your father at Bridge Candy took place on 8th on or after 8th May 2010?
सर डेट याद नहीं है, पर उनका लेफ्ट और राइट दोनों नी का ऑपरेशन हुआ था ब्रिज कैंडी में।
I do not remember the exact
नहीं याद है
date,
सर,
but
पर हुआ है
both of his knees were operated at Breach Candy Hospital.
I suggest to you that the right knee was operated on or after 8th May 2010 and the left knee was operated
sometimes in the month of July stroke August 2010. What do you have to say? Both at Bridge Candy Hospital, Bombay.
यस सर, बोथ एट ब्रिज कैंडी हुआ था उनका, डेट हमको याद नहीं है सर, कोई प्रिस्क्रिप्शन होगा तो वहाँ कर देंगे, नहीं तो हमको याद नहीं है सर, डेट याद नहीं है.
Both operation was conducted at Bridge Candy Hospital, but I cannot see the exact date.
Yeah.
Next.
Do you remember that your father undergone a angiography, बोले ना? Angiography and followed by a angioplasty?
हार्ट का ना सर, अपोलो में हुआ था उनका, हुआ था सर.
याद है?
हाँ.
Yes.
Yes.
Do you remember the month and the year?
सर हमको याद नहीं है सर, हम तो गए थे मिलने भी, हमको ऐसा ध्यान नहीं है.
I do not remember, but I went to meet.
I cannot say the date.
I suggest to you that your father suffered your father had undergone that angiography and angioplasty sometimes in December 2010.
अच्छा सर.
Do you agree with me?
सर उनका हुआ तो था सर, अब डेट का हमको ध्यान में नहीं है सर.
I do not remember the exact date.
But he was undergone the heart problem.
Undergone the surgery.
Do you remember that when did your father suffered the cerebral?
हाँ, वो उसी समय सब था सर, 2009-10 ये सब में था. अब एग्जैक्ट तो आप बोलेंगे तो सब, क्योंकि वो तो हम लोग घर में नहीं थे सर, तो डेट हमको मालूम नहीं है सर, हुआ था उनको.
As I was not at home at that point of time, I do not remember the exact date, but that point of time, I do not remember the exact date, but it was around 2009 and 2010. Sir, छोटा-छोटा okay.
If I say that it is only after the angioplasty operation that your father suffered the cerebral attack, are you in a position to deny me? In December 2010, are you in a position to deny me?
हमको मालूम नहीं तो डिनाई कैसे करें, हमको ठीक मालूम नहीं सर.
I do not know.
I suggest to you that your father suffered the cerebral attack on 31st of December 2010. What do you have to say?
Sir, I do not remember the date.
I do not remember the date.
Yes. What was the position of your father after he suffered the cerebral?
Sir, he
cerebral stroke. Sorry, cerebral stroke लिखा था.
हम तो सर जब मिलने गए, बोल नहीं पाते थे वो.
When I went to meet my father, he was unable to talk.
और जो बोलते थे हमको लगा समझ भी नहीं पाते थे वो.
Whatever he uttered, I could not understand that.
हंसते थे, कुछ बोलने से हंसते थे, ऐसे ही.
He used to smile if anything was said to him.
And after being released from the hospital, are you aware how was your father's health? In 2011, 2012.
हाँ, हमको मालूम है हेल्थ ठीक नहीं था सर उनका.
The health condition of my father was not well around 2011 or 2012.
10 से ही सर, 10 के बाद से ही.
After 2010.
Are you aware of his daily routine, his movements in 2011, 12, 13?
वो हम लोग तो घर में नहीं रहते थे सर, बट वो क्या सिस्टर से कुछ पता चलता था.
We were not at home at that point of time. We used to get some information from my sister.
और कोई कॉमन रिलेटिव्स या फ्रेंड्स से उनसे पता चलता था.
From my sister, common relatives, friends.
by sister, okay, naam bonta?
Sudha Agarwal.
Sir, sir, sir.
Oh, sorry. By your sister, do you mean Shudha Agarwal?
Sir, yes, sir.
Yes.
When was your sister married? Sorry.
When was your sister married?
सर हमारा शादी 84 में हुआ, उसका 2 साल पहले 1982.
In the year 1982.
And where is her? Where she living after the marriage?
Sir, see,
in which place your sister was living after her marriage?
Ahmedabad, sir.
Is she still living in Ahmedabad?
Yes, sir.
Yes.
उन लोग का घर है कलकत्ता में, आती जाती रहती है, पर परमानेंटली अहमदाबाद में रहती है.
They have a house at
Yes.
Preoperative blood reports. Are you aware as to till what time Mr. Murari Mohan Kejriwal used to attend his office at NS Road, which was a joint office along with you?
सर ऑफिस तो जॉइंट नहीं था, हम लोग का अलग अलग ऑफिस था. बाबूजी बैठते थे रूम नंबर 12, हम थे रूम नंबर 2 and 4. अलग अलग रूम ऑफिस था सर.
It was not a joint office. My father used to sit at room. My father used to sit at room number 12, and I used to sit at room number 12, and I used to sit at room number 2.
2 and 4.
2 and 4.
Answer till what time?
अच्छा हाँ.
I said that till what time?
Sir, yes, sir.
Are you aware till what time your father visited that office?
सर वो मैंने बीच में पार्किंग एरिया में उनको शाम को घर जाते इसमें वो जाते हैं देखते थे उनको. वैसे तो कोई मुलाकात डे टू डे कुछ होता नहीं था सर. और
I did not used to meet my father on a daily basis.
बीच में पार्किंग एरिया में मुलाकात शुरू
नीचे.
हाँ नीचे बोलो.
But I used to meet him. I did not used to meet him. Used to meet my father on a daily basis, but I used to meet him sometimes in the parking lot.
हम लोग दोनों गाड़ी के लिए वेट कर रहे हैं उस समय.
At the parking
lot of the office while waiting for our cars.
It was during which period?
सर ये 2010 के बाद में हमको मैंने 11-12 में भी देखे होंगे सर. 2012 में भी देखे होंगे उनको.
These are the events after the year 2010.
Till 2000. Why didn't you go to your father's office and meet him?
सर ऑफिस तो हम कभी नहीं गए, माने तो अलग होने के बाद में 2002 के बाद में.
Sorry, sir.
मैंने we separate
went to after 2002.
After 2002, I never went to the office.
रूम नंबर 12 में नहीं गए सर.
To room number 12.
जहाँ पर वो
father at room number 12.
थोड़ा जोर से बोलिए.
Yes.
चलो ना. हाँ तो क्या ढुकছো তুমি? Give me a moment. Consultation কেসি কেডিয়া রাইট নেম না কেসি কেডিয়া. এটা পড়ে আজকে হবে না. চল এটা একবার দিন ডকুমেন্ট একবার দিন. এই যে এনেছি নতুন এনেছি. What was your financial What was your financial condition during the year 2004-2005?
Not good, sir.
If I suggest that you had you obtained life insurance policies, insurance policies in your name and your wife's name in the year 2004-2005, What do you have to say?
सर थोड़ा सा एक्सप्लेन कर सकते हैं क्या?
This is my lord.
आप लिए या नहीं लिए फिर उसके बाद एक्सप्लेन कीजिए।
कुछ पॉलिसी तो था सर मेरे वाइफ के नाम में, तो 2002 में जब पार्टीशन हुआ।
आपको स्पेसिफिक क्वेश्चन पूछा है कि पॉलिसी
हाँ,
लिए
ठीक है
या
सर।
नहीं लिए, हाँ या ना
लिया
बोलिए,
या
फिर
नहीं?
उसके
हाँ,
बाद
सर।
आप जो बोलना है
हाँ हाँ सर, हाँ सर, यस।
Yes, I have opted.
यस। अब क्या बोलना चाहते?
सर ये 2002 में जब पार्टीशन हुआ तो फैक्ट्री बंद हो गया, तो बजाज इंश्योरेंस का हम 100 घंटा का कोई वो कोर्स किए थे सर, वो इंश्योरेंस एजेंट बनने का। तो फिर उसमें कुछ कमीशन मिलता था, फर्स्ट प्रीमियम में 30% मिलता था पैसा, उसको जोड़ करके वो लोग पैसा नहीं देता था हमको, वो लोग बोलता था इंश्योरेंस ही बनाओ इसका। तो मेकमेट हाउस में गए थे सर, वो मैंने कई दिन तक 100 घंटा का कोर्स किए थे सर, उसी प्रोसेस में हमको कुछ वो बजाज इंश्योरेंस का पॉलिसी मिला था सर उस समय। वो सब वो 2004, 3, 4, 5 का ही बात है सर।
Yes. After selling of the property?
No sir, after selling policy to different people.
After selling the policy to the different people, I got some percentage from the
फर्स्ट प्रीमियम में 30% देते थे सर वो लोग।
I got 30% as the agent of the life insurance company.
Bajaj Insurance.
Bajaj Insurance Company, from which I have purchased the insurance policy.
वो लोग बोलता है कैश नहीं देंगे, पॉलिसी लीजिए तो और बढ़ेगा
Insurance
आपका।
company never used to give the cash to me. They as per their advice, I purchased the insurance policy.
I say that you had purchased 4 insurance policies in the year in December 2004, September 2005, December, another one December 2004, and February 2000, copy date. And February 2005 in your name and in your wife's name. So shown 1, 2, 3, 4 documents. Copy December 2004, September 2004.
September 5, sir.
Sorry, September 5.
December.
In your name and your wife's name. These are the documents in connection with these policies?
हाँ सर, हमारा पॉलिसी आपके पास चला गया।
To answer to the court.
Yes, sir.
Laugh at me, sir.
The document identified by the witness and submit that these are the policies in my name and in my.
See, original
my
premium.
wife. Exhibit 30 on admission. 13. 13 on admission.
It is triple করে দাও।
Collectively.
Triple করে দাও, নাহলে এসব ছেড়ে যাবে।
Collectively.
এটা কি না? রিভার্স সাইডটা, ওহো, না রিভার্স সব সাদা, দেখে নাও, দেখে নাও, দেখে নাও, চেক করে নাও, চেক করে নাও, চেক করে নাও। What was the financial condition of your company, Wellcast Products Private Limited? Wellcast, WLCAST Products Private Limited, in the year 2005-2006?
नहीं सर, 2004-5 में ठीक नहीं था, 6-7 से ठीक होना स्टार्ट हुआ।
The financial condition of the company was not well. Was not well.
Take it.
The financial condition of the company was not well at 2004-2005, but it started to get better after the year.
There are
Get better after
photocopy
2006.
machines now here.
6, 7, 7.
2007.
इसका पीछे में बाकी उनके पास है.
I think there are photocopiers machine now is in court, na? Yes. Na? In court 38 we have one.
That I have made all arrangements.
हाँ, वही question, my lord was there in that court 40.
Paint,
Yes,
scanner, all those things.
Yes,
are there.
everything is there in.
But not in the originals. That
Okay,
not in
okay,
affiliate
okay.
side.
We are taking advantage of the Delhi over there. It's just for the what?
That when I was in the original
Yes,
side,
sir.
I have made all.
You are taking advantage of it. Delhi in that court. 40, 41, we are taking it.
41 I kept, then after 31,
30.
38.
That I'm thinking is must be a photocopier here also.
सर उसमें पॉलिसी में एक बात और बोल दें क्या, एक ऐड कर दें कुछ, जो पॉलिसी दिखाया था सर, ये जो पॉलिसी दिखाया था आप, उसमें एक बात और बोलना था. सो 1,50,000 प्रीमियम पेमेंट
वॉलंटियर्स
वो जो पॉलिसी आप 4 दिखाए थे, 1,50,000 रुपए का प्रीमियम पेमेंट हुआ था उसमें. सम एश्योर्ड ज्यादा, पेमेंट 150.
बोल दीजिए ना, बोला था, फॉरवर्ड कर दो.
150 प्रीमियम पेमेंट सर, 4 पॉलिसी.
The all 4 policies having the 1
Total
1,50,000
1,50,000
1,50,000 premium.
Premium
total.
paid in total. হ্যাঁ, আগে আনসারটা কি বললো, যে ফিনান্সিয়াল কন্ডিশন অফ ওয়েলকাস্ট কি বললো?
Not good.
Was not good.
Yes.
Copy that. I'm showing you the certified copy. এটা কি বলে? Of annual return. Annual return of Wellcast Products Private Limited for the year ending 31st of March 2006. Copy देता हूँ. এই ফ্ল্যাগটা খুলে দাও. Kindly come to the 8th page of the document. Are you in a position to identify the 3 signatures appearing thereat?
सर पेज नंबर तो है नहीं.
না, just এমনি করে
আচ্ছা, এমনি করে
3, 4, 5, 6, 7, 8 turn over 8.
সবই তো একই সিগনেচার আছে. হ্যাঁ বলুন.
না, are you in a position to identify the 3 signatures?
হ্যাঁ.
Yes.
একটা তো স্যার ওই অঙ্কিত কেজরিওয়াল মাই সন.
The first signature is of Ankit Kejriwal, my son.
कोने का बासु सर है सर, मिस्टर तरुण कुमार बासु.
The second signature is of Mr. Tarun Kumar Basu.
बासु. और एक सिग्नेचर है मिस्टर रविंद्र सरावगी.
And another signature is of Mr. Rabindra
सरावगी.
Saraugi.
In the second page of this, in the first page, second page you have it. Third, in the third page of this document, which bears the director's report to the members, do you find that that the company was having substantial profit after tax from 2003 to 2006? ঠিক পেজটা দেখছো? আগের পাতা, पहले वाला.
Third case.
नीचे देखिए, यहाँ है. देखे नहीं जाइए.
बोलिए सर.
না, কোশ্চেনটা বলে দাও না. না, do you find company was having
नहीं, ये तो गलत है सर, आप जो बोल रहे हैं.
No, this is wrong.
kindly come to the second box, which starts with the heading, the following indices will provide a more accurate comparative view of the company's growth. A more accurate comparative view of the company's growth which records profit after tax for the year ending on 31st of March 2003, এটা কত is 100 lakhs. The profit after tax in 2004 is 384 lakhs. For 31st of March 2005 is 517 lakhs. And for 31st of March 2006 is 686 lakhs. Do you find this?
Yes, sir. But आप सर सही नहीं समझ रहे हैं इसको. माने your understanding is not correct.
बोलছে লেখো.
But you are getting this wrong.
सर ये जो 100, 384, 517, 686 जो देख रहे हैं आप, ये लाख नहीं है सर. 100 एक नोशनल फिगर है. 100 यदि हम 100 रुपया कमाते हैं 3 में.
यस बोलिए क्या बोलना चाहते
सर ये बोलना ये चाहते हैं सर, सेल हुआ है 65 लाख, उसमें 100 लाख बोलते प्रॉफिट हो गया.
हैं? आपका क्या बोलना हुआ अमाउंट के बारे में?
सर अमाउंट ये जो बोल रहे हैं वो लाख नहीं है सर. That is not lakhs.
The
Number one.
amount mentioned in the said paragraph is not in lakhs.
सर ये एक नोशनल फिगर है 100. मान
The
लीजिए
notional figure as 100.
तो हम लोग सब कमाए 20,000 रुपया. हम लोग 2003 में 20,000 रुपया कमाए हैं, उसको दिखा दिए 100.
If I earn
If I earned
in 2003, so we have shown as rupees 100.
100. सर 2004 में हम लोग 80,000 कमाए हैं सर, तो 4 गुना हो गया प्रॉफिट, तो 384 लिख दिया उसको सर.
We have earned as 80,000 in 2004, so we have shown as
384% या 384 times.
384.
सर 2005 में हम लोग 1,70,000 कमाए हैं सर.
In 2005 we have earned 1,75,000.
तो सर 100 का 500% हो गया, 517 दिखा दिए हैं यहाँ पर.
So we have shown as 517 as 500 what percent?
517 सर.
As 517.
और सर लास्ट जो 2006 है सर, 2006
and in 2006
राउंड फिगर 3,50,000 प्रॉफिट दिखा रहा है सर. 3,50,000 उसको दिखा दिया 686 ऑफ 100 का 7 गुना.
we have earned rupees
सर 3,50,000 3,50,000 सर.
50,000 and we have shown as
686 times
86
100 का मतलब 686 मतलब नंबर. तो ये ऐसे देखने में अच्छा लगता है सर. 100 का 700 हो गया.
I suggest to you that in terms of this annual report, your company had a total earning in foreign exchange during the particular year of more than 7 crores as reflected in this document.
एक सेकंड, इकाई दुहाई सैकड़ा.
It's a suggestion you made.
10 लाख करोड़. हाँ 7 करोड़. एक बार सर. इकाई दुहाई सैकड़ा. लाख 10 लाख करोड़. हाँ.
Foreign exchange earning.
हाँ सर ये.
Yes.
यस सर. हाँ सर क्वेश्चन बताइए सर.
No. I suggest to you that the total earning of your company in foreign exchange is more than rupees 7 crores.
Yes, sir.
Yes.
It is correct.
Yes, sir.
Yes.
In 2006.
Next. So it will continue or?
No, I'll mark this document as an exhibit because the document will go, it will speak for itself. On admission,
That's all.
Yes,
This
for today.
document?
Yes. 14.
What is the document? What is the document?
This is the annual return of Wellcast Products Private Limited for the year ending 31st of March 2006. It exhibit
Marked as exhibit
14.
14 on admission.
14 or 8 or 13.
14 on admission. Huh? Yes, recorded. Defendant is present. Cross-examination resumed, but during his cross-examination, two documents were marked as Exhibit 13 and 14. Due to paucity of time, examination in cross-examination. Accordingly, cross-examination is deferred. Let the matter appear on 16 July at 3 p.m. for cross-examination. Further cross-examination.
16 July.
Yes.
ঠিক আছে আমারও তো 16 জুলাই নেক্সট ডেট আমরা এই রথে ছুটি নেই তো 16 জুলাই রথে ছুটি নেই ঠিক আছে ঠিক না না ভাই হাইকোর্টের ভরসা নেই রথযাত্রা অবলাইজমেন্ট রথযাত্রা ঠিক আছে
If your lordship recollects, this is that Zoroastrian trust matter. There was an application by the trustees seeking leave to sell a property at Lenin Sarani. Initially, your lordship had appointed a special officer. Based on the report of the special officer, there was an intervener who was to intervene from Bombay. Mr. Zaiwala. So Mr. Zaiwala was permitted to intervene, affidavit taken, exception filed to the report. Thereafter, your lordship considered and passed an order for sale of the property on certain terms and conditions with the direction upon the special officer to conduct the sale. My lord, kindly take your lordship's order, which is at page 88. This will bring back to your lordship.
Mr. Zaiwala, you have sent one reply.
Yes,
yes,
you have.
please. Yes,
Yes.
please.
Which will be
Yes.
filed a rejoinder.
Yes, please. Lordship, I have also given it to the registrar to be please placed before you, and I have also given certain judgments. It has been received by your court on received by the Calcutta High Court on 3rd June, because the lordship, the advocate, on 25th due to multiple organ failure.
Okay.
So does your lordship have the reply filed by the intervener? Otherwise, I have an extra copy if your lordship wants, I can give your lordship one. Because he says it's filed to the department.
No, you're not received.
No, I have received. If your lordship doesn't have it on record, very well. Then we'll give your lordship one.
Received through post.
Yes, post. My lord, kindly come to page 88 of the application. This is your lordship's order of 14 July 2023.
Yes.
My lord, this records that in compliance with the order passed by this court on 14th March, the special officer had submitted 2 separate reports of such and such after circulating the same to the learned counsel for the petitioner and to the intervener. On receipt of the report, the intervener has filed the exception to the report of the special officer. The court appointed special officer ascertained the following. My lord, this is the ascertainment. Then the conclusion. Thereafter, my lord, kindly take paragraph 3, which is the objections of the intervener.
Yes.
At page 90. Such and such, learned advocate in person for the intervener submitted that the report submitted by the special officer is contradictory to the special officer. As the special officer mentioned the report regarding 84, commercial such and such, these are the such and such, then my submissions are recorded. And then kindly take my lord para 6. After considering the report submitted by the special officer, this court finds that the building in question is 100 years old and has not been properly maintained. Rent as calculated by the special officer after taking into consideration the fair market rent value of the surrounding areas of the premises and the present condition of the building of the trust, the monthly rent for the super built up area for the residential such and such, and super built up. It is also a fact that the said premises there is no lift. The intervener has raised objection with that the party has kept vacant. All these objections are considered. Then my lord, kindly take para 8. In view of the above, this court finds that the report submitted by the special officer does not suffer any perversity and illegality. Accordingly, the same is accepted. Now the question arises whether the leave can be granted to the trust to sell part of 89 Lenin Charani such and such. Then, my lord, your lordship records everything, and then, my lord, kindly come to para 13 at page 94. After considering the report of the commissioner and the resolution taken by the trustees and the objection raised by the intervener, this court finds that it would be proper for the benefit of the trust to allow the petitioners to dispose of part of 84 such and such, the application by way of sale. Then, my lord, this is the manner in which your lordship directed the sale to be conducted. Then, my lord, kindly see, my lord, what it required is the special officer will ascertain the present market value, make publication in 3 leading newspapers, and after getting the best price, the petitioner shall place the same in a meeting of the trust for approval. Upon approval, conveyance to be made.
Yes.
Now, my lord, what happened? I'll tell you, lordship, my lord, what happened thereafter. My lord, publication was made, no offers were received. The only offer that was received, my lord, the first I must tell you, your lordship, indicate to your lordship, my lord, what was the market value which was ascertained by the special officer through a valuation report. My lord, the valuation report is at page 96. The relevant portion of the valuation report is at page 100. Please sit down. If I have any query, I'll ask you.
7 crore 83.
Yes.
5.2 crores. Yes.
If you think I'm not prepared, I am not one of them, so don't worry. My lord, there's a valuation report which starts at 96. The relevant portion your lordship will find at page 100, which is the valuation ascertained by the valuer, which has been taken 5,783. Now, my lord, your lordship direction was to sell it at the market value. Now, this is basically the problem why we are back to your before your lordship, because we, upon publication made, we did not receive any offer which was, I would say, either higher than the value or closer to the value. Well, the only offer that we received for the property was from one Mr. Abdul Kalam of rupees 6 crore. Well, kindly have a look at page 1061. This is the only offer that has been received by the trust and or the special officer. So, well, now, what is to be done?
Yes.
Your lordship order says market value. So, we can't, special officer naturally cannot sell it below the market value. So, my lord, we trust. And my lord, it was the considered view of the trust that the matter should be placed before this court for reconsider. Otherwise, we've not been able to sell it. So it's been almost, well, a little more than a year, in fact. Your lordship's order, if your lordship see, was of 2023. Almost 3 years have passed, my lord, we haven't received any offer. Now, my lord, now comes, now what do we want now? My lord, there are 2 ways of looking at it, my lord. What we are seeking is, my lord, certain modification of your lordship's order so that this bird in hand, which is who's offering 6 crore, we can either accept the 6 crore or request this gentleman who's giving 6 crore so that the property can be sold. Well, at Bombay real estate market, from where the intervener is appearing, and the real estate market of Calcutta, one has to be realistic about the real estate market. Well, there's a difference between Delhi market, Bombay market, and Calcutta market. So they don't understand the Calcutta market is possibly the worst in the country as on date. We hope it will change, it will get better, but till now it has not got better. But this is the situation, ground reality. We have to accept this. Now, my lord, the objection that the interveners once again raised. So his object is to intervene. An object, very well, he has a right. If he does, now what does he say? He says that the market value is 783, that we are selling it for 6 crore. That's a loss to the trust to the extent of 1 crore 73 lakh. So my lord, my only answer to that is, let Mr. Zaiwala and his associates get us a buyer from Bombay who's willing to pay 7.83. And my lord, kindly confirm the sale in favor of any person. Now, 3 years have passed and the property value, my lord, is not increasing, is depreciating by each passing day. And we've not been able to get one. So, my lord, we are in a situation which is irreparable, unavoidable. So that's why we are back before your lordship, my lord, seeking directions to modify the order so that the property can be sold to this person or to any person who is willing to pay higher. Because we haven't found any, despite the publication made in three dailies by the special officer, not one, but 3. Now, if your lordship takes the objection once, objection to the Lord, kindly take the objection of the intervener. Well, according to me, it does not even deserve consideration, not worth the paper. Because what he is doing is causing prejudice to the interest of the trust. Well, kindly take para 4. This is only objection. Causing loss of 1.83 crore. This is according to him, this is his understanding of the entire application, steps taken by us since 2023.
Yes.
Previous intervention. So this is what it is. This is what we're seeking.
Yes, Mr. Jaiwala.
Can I start my argument, Your Lordship? I'll complete it in less than 10 minutes.
Yes.
Sir, Lordship, we'll first start with their application, page 19. Page 19.
No, you tell me if
I'll come to everything. So I just require 10 minutes. I'll come to everything, every query. But
you
I,
will burden,
I'll
then
come.
court will direct. Okay, you
I-
raise the objection. I am giving.
I just require 10 minutes to complete my arguments, please, if I'm permitted. The learned friend says, I am from Bombay. I'm not repeating, this is already argued. Page 19, the expression, wherever it shall occur means Parsi, including an Irani Parsi who is about 21 years.
See, the court is not going into that. You are from
I'll come.
Bombay, Lucknow, or the
Okay, Your
court.
Lordship, I will come to that. I will.
Court has
Your
called
Lord-
for the report. Report has come. 780. The court has submitted the 780. No purchaser are coming.
Yes,
One
I
purchaser
will-
has come to purchase the 6
Yes.
crore.
I will
Your
come.
contention is that the 6 crore they are selling the property 1.8 crore lesser the market
Yes,
value.
I will come to that. I will come.
For your favor consideration, so I will give you liberty for 1 month. I am giving you.
No, I just allow me to complete my argument, Your
Local
Lordship.
purchaser either from Kolkata, Bombay, everywhere of India.
Your
If
Lordship.
any person is coming a 7.80, the court will accept that there is no
Your
problem.
Lordship,
The court has
I'm begging to give me only 5 minutes to complete my arguments. That's all. If I'm permitted to. Please, Your Lordship, page 99, can we start?
Yes.
Page 99. Page 99. I will start with their admission. Report. The value of the land as assessed by registration officer for stamp duty purposes is 5 crore 88 lakhs. However, in different case laws, it was noted that the basic valuation as accessed by registration department is for the collection of stamp duty, hence the same cannot be considered. In this case of Javanan Naganatham, the court held that it is therefore clear that basic valuation register prepared and maintained for purpose of collecting stamp duty has no statutory base or force. It cannot form a foundation to determine the market value mentioned therein under the instrument brought for registration. Evidence of bona fide sale between willing prudent vendor and prudent vendee of the land acquired or situated near the land possessing the same advantages would furnish. Now, your lordship, kindly see the next page. The stamp duty value is 5 crore 88, but the market value is 7 crore 83. That is the court appointed. Am I right?
Correct.
Now, kindly see my reply. Your lordship will kindly come to my reply, page 5.
Yes.
Page 5. This was given to me by Mr. Firoz Edilji before he died, senior counsel.
Yes.
Your lordship, now kindly see the ready reckoner stamp duty valuation has increased from 588 to 733. That means the market value will be even higher. This is not my valuation. This is Government of Bengal.
Which property it is?
84 Lennon Sarani. This was given.
Where is
730. So kindly see one line above. Premises 84. Just before he died, Mr. Firoz Edilji gave me this document.
Yes.
Now that means from 589, it is 733. So market value will be even higher. Now I'm coming only to one Supreme Court judgment on this issue, Your Lordship. I have already attached it.
That's right. So if you go by that, the 733, here the 783.
No, sir. Your High Court report says the stamp duty ready reckoner is 588, but the market value is 783. Here the stamp duty itself shows 733. In 3 years, kindly see the increase in valuation.
Okay.
Come to page 101. I will respect the learned counsel for the other side, but kindly come to page 101.
Yes.
Now, page 99. Valuation. Stamp duty purposes is 588. Your Lordship has seen it. Now, kindly see 2023 and 2026. How much is the stamp duty valuation which has increased? Kindly see this. 733, even the stamp duty valuation has increased. The market value will be far higher. Now, I'm not coming in between the sale. This court has already decided that we are going to sell the property. All I'm requesting is kindly go through Your Lordship, the Supreme Court judgment on this issue, which I have attached. 1986, this judgment has been followed half a dozen times later by Supreme Court. I will just send to Mr. Debago Basu. I will send him also a copy. He will receive it in WhatsApp in 2 minutes. Your Lordship, now kindly.
Yes. Tell me.
I thought Bombay has better connectivity. We are better off. এতক্ষণ ঠিক ছিল you entered Heathrow আমি কি করি ঠিক ছিল this right of intervention ought not to have been given to him in the first place. But now people should be willing to invest from Bombay in Calcutta. Earlier, nobody was. But now real estate market, we'll be happy if he gets an investor from Bombay who's willing to invest in Calcutta.
How this valuation has come?
I'll tell you, Lordship, this is a part of the property is being sold. 4 out of the 5.5 katas. Kindly see the valuation that he is taken out. This is on the entire property.
5 khata.
And my lord, your lordship, the report shows part of the property is being sold. In any way, now my lord, it is well settled. The set forth value is the market value. If you sell it for lower, then it will you have to give the deficit. On the deficit, you will be charged with income tax on wealth tax. You'll be taxable on the portion which is less than the market value.
No, he's taking the plea. Now he got the 733.
Very good.
And if you go by the report of the valuer, so he's
Yes.
telling that the stamp duty value cannot be considered. Then again, if it is considered, then it will be again increased. Page 99.
Yes, my lord.
Page 99.
Yes.
5.8 ko tha. SSS 5 crore 88.
Yes.
But in case of Journalist Johnson, the court held that therefore the clear that the basic valuation register prepared and maintained for the purpose of collecting stamp duty has no statutory base for force. It cannot be formed foundation to determine the market value
Correct.
mentioned there under in instrument brought for the registration. Evidence of bona fide sales between will prudent vendor and prudent vendee and they acquire the situation near about it. So he's telling that if we excess, then again the market
So,
value.
my lord, if your lordship recollects, while sitting in courtroom number, my lord, 38, we argued on market value can be whatever. But once the property is on auction in the public domain, I could have got 30 crores for that also.
Yes.
So if we had got a buyer for 10 crores, 12 crores, 15 crores, could we have said no? It was with the special officer. Question is today that we haven't got a buyer beyond 6 crore. That's the reality. So that's why we say, my lord, that's why we are back in court. So one of the market value, index value, the value with the, it is irrelevant for the purpose of sale because we are not getting a buyer for that value.
Your Lordship, am I permitted to read the judgment, the relevant paras?
Yes, yes.
The connection was lost. I will start with first para. Sale of property belonging to public and religious charitable endowments by private negotiate. I'll wait, Your Lordship, till you get it.
Just get the citation, we'll download it right away.
I'll give Mr. Debag. I'm losing the connection. Once I send in the judgment online, I'm losing the connection. That is the problem.
The citation will do.
Yes, just I am giving the copy.
Your Lordship.
I've given an extra copy for them also, Your Lordship. I've given an extra copy.
86 3SCC 391.
Yes.
Am I permitted to read?
Yes.
Line 2. Sale of property belonging to public, religious and charitable endowments by private negotiation, essential precondition, government side. Now kindly see the next para. Auction, public auction, disposal of public property should normally be done by public auction with full application of mind by competent authority. Reserve facts must be fixed having regard to the market value. Now, Lordship will come to next page of the Supreme Court judgment.
Yes.
This is the second para. Public officials and public-minded citizens entrusted with the care of public property have to show exemplary vigilance. The property of religious and charitable endowments or institutions must be zealously protected, for a large segment of the community has beneficial interests. That is the raison d'etre of the Act itself. The authorities exercising the power under the Act cannot afford to take things under face value or make less than the closest and the best attention approach to guard against all pitfalls. Sale by private negotiation, which will not be viable to the public eye and may even give rise to the public suspicion, should therefore not be permitted unless there are special reasons. And care must be taken to fix the reserve price after asserting the market value for the sake of safeguarding the interests of the endowment. The Lordship will now come to para 10. This is very important because this gives the gist of the judgment. Para 10. We cannot conclude without observing that property of such institutions or endowments must be zealously protected. It must be protected for a large segment of the community had beneficial interest in it. The authorities examining the powers in the Act must not only be alert and vigilant in such matters, but also show awareness of the ways of the present-day world, as also the ugly realities of the world today. The Honorable Supreme Court has, in a few words, spoken a lot of things.
That's why I'm telling, without going into...
Your Lordship, I am only saying, let there be a public auction. I have nothing to do with it.
I am appointing you a special officer.
No, I don't want to be. I am only requesting, let there be a public auction, Your Lordship. If I'm
judicial order, I am appointing a special officer to you.
Not to me, sir. I cannot be appointed. I am a beneficiary.
Order if required. I am appointing because you are not satisfied with anything.
So I leave it to the court.
I am
leave it to the
appointing
court.
you as a special
Sir,
officer. So
I
whatever
cannot
the-
accept. I
No, no,
cannot
but
accept it, but I will respect what. No, no, sir. I leave it to the court. Whatever you wish to, whatever you wish to pass, I leave it to the court.
No, but you are
I
telling,
have-
see, if today also, if we got the 8 crore rupees of the market value, the public is
No,
not
I
coming,
will-
the
I
public
will-
is been made, you are telling that the court is biased.
No, sir, not at all. If you please understand this.
Meaning
Please
of
understand.
that,
No, sir. I am talking about where all over India trustees sell the properties. Please understand that, sir. With folded hands, I'm saying.
selling the
I-
property.
No,
The
I'm.
officer was appointed.
No,
The
I understand.
report has been called for.
Sir,
Application has
Sir,
been
with,
made.
with, fold, with folded hands, I'm saying let there be a public auction, and I have nothing more to say.
I am appointing you.
No,
and you
sir, I cannot be. I have folded hands, sir, as an advocate, as a brother advocate. I'm saying with
Yes,
great
sir, you are the
respect to the court.
advocate. You are the advocate. Who are the advocate appointing you?
No, sir, I folded hands. I'm saying
that matter can be
with
closed
folded
once.
hands. I
Kindly
leave it to the court. You can
If he
close it.
cannot get a better buyer, then he should pay the cost.
I
Cost
am-
of the advertising should
Sir,
be paid.
sir, my father is a 83-year advocate. He has gone through a brain surgery. He's the party to it. I am coming and defending him because he's very sick.
That's why you are not
Okay, I will-
satisfied with the report.
Okay, I will. Okay.
Special
Okay,
officer
okay, your lordship.
So you are not satisfied.
Okay, your lordship,
That's
permit
why
me to
I
withdraw.
am presenting
No, no,
you.
permit me to withdraw this
I am
application. If the court feels I'm done, permit me to withdraw that.
presenting you. You
No,
take
no.
the. I am
Sir,
giving one time.
Sir,
to
no, sir, permit me to withdraw the
whatever it
application.
is.
Permit me, sir, permit me to withdraw the application. If your lordship feels the application is unwarranted, permit me to withdraw it.
I am permitting you. I am appointing you as a special officer.
No, sir, at Bombay, I cannot be possible to come to Calcutta. With folded hands, I'm saying, sir, I have only argued for the matter. With folded hands, sir, please
Application
consider this.
of
I will
the
withdraw the application.
14th July
I am
2020
requesting.
by fixing the reserve price at rupees 6 crore.
I'm folded hands, sir. My father is very sick. He's gone through a brain surgery.
Well,
And I'm only arguing, sir. I cannot
of-
appear. I have come free. Please, sir, consider it. As a public issue,
the petition. Learned counsel for the petition submits that.
I have never made any accusation on the court. I am saying Supreme Court judgments on the issue. There should be a public auction for all trust properties. That's all. Please consider that. I'll withdraw the application. Permit me to withdraw it.
This court dated 14th July 2023, comma, the special officer has appointed a valuer.
Yes.
To ascertain the present market value of the property in question. And accordingly, the valuer, considering the present market value.
I'm withdrawing my application. Your Lordship, permit me to withdraw the application with folded hands. Please, sir. My father is sick at 83 years, and I have let me withdraw the application on his behalf, sir. Kindly consider.
Yeah. Then now the court will test you.
Folded.
File the क्या बोला?
Sir, I am just a beneficiary.
As rupees 7 crore 83 lakhs. 7 crore 83 lakhs.
Consider.
After obtaining the market value, comma, the special officer has published the notice for sale of the property by fixing the base price of rupees 7 crore 83 lakhs. The notice was published in the English daily newspaper, in English, Hindi, and Bangla newspaper.
Yes.
Newspaper. In spite of publication of the notice in 3 news.
Permit me to withdraw.
Of the
with folded hand, I'm saying permit me to withdraw, sir. My father is very sick.
Property at the rate of 7 crore 80 lakhs. Subsequently, full stop. One proposed purchaser by a letter dated 14th July 2025 informed the petitioner that the said one proposed purchaser, namely Abdul Kalam, by a communication dated 18th July 2025, informed the petitioner that the said proposed purchaser is intending to purchase the said property at the offer of rupees 6 crore. 6 crore, subject to the condition that the land is free from all encumbrances, physical measurement, possessing and holding of the aforesaid property in vacant condition. Full stop. Now, counsel for the petition submitted as this court has directed the special officer to conduct the sale as per the market value, but as per the market value, none of the proposed purchaser has come forward to purchase the property. Only one proposed purchaser has come who has quoted a rupees 6 crore, and as such, unless and until the order dated 14 July 2023 is modified by allowing the petitioner or the special officer to conduct the sale at the rate of 6 crore, it is not possible for the petitioner as well as the special officer to conclude the sale process. Full stop. Mr. Khushru Jaiwala.
That's my father, 83 years old, sir. Brain surgery he has gone, so he cannot walk advocate.
Petition was filed for modification, 22nd April. He intervened and
Yes,
wanted.
but he cannot be physically present every time, so I'm appearing for him from the High Court.
Your Lordship gave liberty.
Mr. Raymond Jaiwala, an advocate, had intervened in the matter, and accordingly this court allowed Mr. Jaiwala to argue the matter. Accordingly, the copy of the petition along with the document was served to the intervener, to Mr. Jaiwala. Mr. Jaiwala has submitted a written reply along with by enclosing the valuation issued by the Government of West Bengal Directorate of Registration and Stamp Duty. It is the contention of the intervener that the petitioner has relied upon the market value issued by the Government of West Bengal at the rate of rupees 5 lakh 88,000, 5 crore 88 lakhs.
Page 99.
Five crore 88 lakhs 94,751, but the intervener has obtained the market value on
not market value, sir. Stamp reckoner value.
Stamp.
No, that is the market value.
Yes,
Your
here
Lordship will
is the
see that
market
column.
has obtained the market value.
Stamp
Said landed property, which reflect that the total
Just
market
stamp.
value is 7 crore 33 lakh 70,000 004. Full stop. Learned counsel for the petitioner in its objection further stated that as per the market value submitted by the valuer, the total market value of the property is rupees 7 crore 80 lakhs, but the petitioner are intending to sell the property at the rate of rupees 6 crore, that is less than 1.80 crore of the actual market value, for which the petition society will be affected. Full stop. Had the learned counsel for the respective parties peruse the materials on record. This court finds that whenever the matter has been taken up for hearing, one or the other reason, the intervener is appearing in the matter and intervening in the matter.
I will be allowed to withdraw, Your Lordship.
One or the other issues. Now, in the present case, the specific plea of the petitioner that the market value is rupees 7 crore 80 lakhs, but in spite of the publication of the notice for sale of the property, none of the proposed purchaser has come forward for purchase of the property at the rate of rupees 7 crore 80 lakhs. And as such, one proposed purchaser has come for rupees 6 crore, and the petition intending that the order dated 14 July 2023 is to be modified by allowing the petitioner to sell the property at the rate of rupees 6 crore. But the intervener are not ready and are of the view that the property is 7 crore 80 lakhs, it is to be sold on the said rate. In view of the above, this court find that the intervener is very interested in the property in question and very serious about the property. Thus, Mr. What is your good name, sir?
Sir, I am not
Raymond
interested.
Zaiwala.
Raymond Zaiwala is
Sir,
the
I am the
father.
advocate. How can I be
Sir,
made a
he's-
party, sir? No, sir, Kushru
he-
Jaiwala. Rayoman
What is
Jaiwala.
your-
Yes, sir, Rayoman Jaiwala, Rayoman Jaiwala.
Your name
Sir,
is?
I am Rayoman, Rayomand. Sir, I am only a counsel, sir. Please understand, I have not even filed my Vakilat Nama in this matter.
You have not
I have come to argue. I will
any
withdraw the application. Your Lordship, permit me to withdraw the application and let them go ahead if they want to.
Objection.
Who, being the advocate as an intervener, has appeared in the matter from time to time, is appointed as an special officer.
Yes.
A special officer for sale of the property.
Sir, I cannot leave my father. He's bedridden. I cannot leave him alone.
Than that. Accordingly, Mr. Zaiwala is directed to publish the notice for publication for sale of the said property in the English, Hindi, and Bangla newspaper.
Or in Bombay also, let him
Anywhere
publish.
in India.
Anywhere in India.
And
Let him-
anywhere India, and to file a report before this court whether any proposed purchaser has come forward to purchase of the property. Let the report be filed within. Let the report be filed on or before 24th of July 2026. After serving the copy to the learned counsel for the petitioner, list the matter on 28th of July.
Sir, let them give me all the documents what they want to sell. At least that they can give me.
Advocate. Yes.
Wait.
Item 4, my lord, I appear for the petitioner. But may I file my affidavit of service, my lord? But one difficulty has arisen here, my lord. I must state this fairly, is that my dispute was predominantly with State Bank of India. Lord, their failure to act fairly, which I'll demonstrate from the papers. Now, while the writ petition was pending, we received a communication from State Bank of India that the concerned loan account, in respect of which I had deposited an earnest money, which was subject to finalization of the loan account, which ultimately did not materialize. They were supposed to refund it back to me. The terms and the conditions were very clear in that respect. While all this was pending, we received a communication that the loan has been assigned to Kotak Mahindra Bank, and therefore they'll not be in a position to appear in this matter. Lord, today I'm just seeking for one prayer because I cannot obtain any order in absence of State Bank of India. Your Lordships, if your Lordship pleases, kindly, my Lord, direct State Bank of India to, my Lord, appear, my Lord, in this matter, because my principal grievance is against State Bank of India.
Which branch? Which branch?
My Lord, this is, my Lord, Middleton, my Lord, Stressed Asset Recovery Branch. If your Lordship sees the cost title, page 2, respondent number 2, Stressed Asset Recovery Branch, State Bank of India, New Delhi.
The petitioner has filed the affidavit of service, but in spite of service of notice, none appears on behalf of the petitioner. This court find that the appearance of the State Bank of India is necessary. Accordingly, okay. Okay. क्या बोला? Necessary. Accordingly, the petitioner is directed to inform the next date of hearing to the respondent number 1 and the respondent number 2 and to file the affidavit of service on the next date fixed. it is made clear that in spite of service of notice, if none appears on behalf of the respondent number, on behalf of the bank, comma, the writ petition will be taken up for hearing in the absence of the respondent of the bank.
May I just make one prayer, my lord, if it matter can have some precedence, my lord. I know your lordship's list is, my lord.
Let the matter. How soon you will file serve the notice?
We'll serve it, my lord, today itself, because my client has some urgency in this
Let
matter.
the matter appear on 23rd within two matters.
Grateful, my lord.
Next. इसका क्या है बताओ? Yes, what is the matter?
My lord, I am not prepared with the brief.
You are not prepared with the brief. Then why you are coming to the court?
I just came to mention for some.
परसों कल परसों भी मत कर, परसों भी वही रहेगा। 22 तारीख को